ಲಾಸ್ಟ್ ವೀಕ್ ಮತ್ತೆ ಬೇಡ ಅಂತ ಅಂದ್ರು
is the KLGP matter. My lords, the cognizance has been taken and an interim order has been passed, my lords. Staying proceedings, staying alienation. My lords, matter may be had on Wednesday, my lords. We have challenged the same before this honorable court.
ಯಾವ ಡೇಟ್ಗೆ ಅದು ಅಪಿಯರೆನ್ಸ್ಗೆ
13th ಇದೆ 13th
ಅಪಿಯರೆನ್ಸ್ಗೆ
ಹೌದು
ತೊಳಿ ನಾಳೆ ಹಾಕೊಳ್ಳಿ ನಾಡ್ದು ನಾಳೆ ನಾಡ್ದು any day will do. Great.
With my lordship's permission, my lord, serial number 38.
13
Well, more than two. I
38
think for a very short accommodation, my lord, any day.
all next week ಹಾಕೋಣ
Next week, my lord, that batch matters are coming. That is coming on 19th.
19th ಹಾಕೋಣ
19th ನಂತರ ಹಾಕೋಣ ಯಾಕಂದ್ರೆ these are 6 matters. That will take some time.
38 ಏನು ಇದರಲ್ಲಿ ಏನಿದೆ ದಿಸ್ ಇಸ್ ಇಲ್ಲ ಕೊಡಲ್ಲ ನಾನು ಐ ಹ್ಯಾವ್ ರೆಡ್ ದೀಸ್ ಪೇಪರ್ಸ್ ವೆರಿ ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ ಇದೆ ಶಂಕರ್ ಅಪಿಯರ್ ಆಗಿದ್ದು ಅದರ ಡೇ ಅದೇ ತಾನೇ ಇದು
This is a matter, my lord, where my lord sales was done, my lord, less than the cost price, and my lord it was
different man
different and we said, my lord, department said it's nothing but creation of, my lord, goodwill or, my lord, trade, and so the expenditure borne by the
will is also property or
it is an asset, so it has to be capitalized in the Namavada. So I'll take little time, my lord, for preparation. Any day it can be had next week.
My lords, may submit in item number 38.
38
My lords, there is this Vivad Se Vishwas scheme which the SSC has opted in these matters and they are pending before the authorities. That's why we also wanted to have, get this adjourned for some time so that these matters can be
both call next week. Okay.
My lords, may put it slightly for a longer date because the applications are pending. Once
2
it
weeks.
gets grateful, my lords.
And my lord, serial number 37, actually it relates to the same respondent, my lord, in the batch matters, which is listed on 19th. It can be listed just
19th.
after 19th also.
19th
May I pass on the appeal numbers that it has to be tagged with, my
Kadi,
lords?
call along Kadi.
My lords, may I make a request in serial number 28, my lords?
28
Could it be taken up tomorrow for admission?
tomorrow, not today.
My lords, there's some inconvenience today.
It appears for appellant, my lord. The issue is pending before Supreme Court, my lord.
Is it pending before the
My
apex
lords, my
court?
submission is, my lords, this very issue has arisen in my own case for multiple assessment years. And the
Decide.
tribunal had held in my favor. The revenue has not challenged those before this honorable court.
Some of
That being the case, some they have not challenged, some they have challenged.
Next week, madam. Sorry, at the request of.
Would it be at all possible on 19th, my lords?
No, it comes someday. Yes.
My lords, may I request 31 and 35 also, my lords?
One case, one lawyer, one case ಇದು.
My lords,
Huh.
if my lords at all would consider taking 31 and 35 up tomorrow?
31, 35 next week. Yes, at the request of.
My request for serial number 26, Your Honor.
35, your lordship recall is that where the tribunal has been directed not to proceed on that issue.
Perhaps we have to grant relief to them. Because we directed. As long as issue is pending here, they are not supposed, there is such a section.
My expectations are
The 35, we may grant relief to you in 35. Wait,
Could it be taken up tomorrow, my lords?
even when we want to grant relief to you.
No, my lords, the only thing is I have instructions to brief a senior advocate in this matter. Would it at all be possible tomorrow?
Next week, call next week. Okay.
My request for serial number 26, Your Honor. Here has gone through your operations of prayers time for adjournment, Your Honor.
Which matter?
Serial number 26.
ಏನಂತ?
serial number 26.
26.
The serial has gone undergone.
ಇದೆಲ್ಲ ಎಷ್ಟು ಕೊಟ್ಬಿಟ್ರೆ ನಾವು ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗೆ? All right. 2 weeks? 2 weeks at the request of.
My lord, serial number 21, it's for preliminary hearing. My learned friend is there. There's a short accommodation, my lord. I have to take some short instructions on that matter.
21?
21, my lord, that's.
All right.
Next week it's.
All right.
Your Lordship, may I make a request?
Huh.
Your Lordship, in serial number 43, I'm
40?
43, Your Lordship.
43. ಇದು ಓದ್ಕೊಂಡ್ ಬಂದೇವು ನಾವು.
Your Lordship, I'm praying for a short accommodation, Your Lordship. There is outstation counsel who will appear in this matter.
All right, next week. Next week you do it.
Yes, Your Lordship. Can it be posted on 17th February, Your Lordship?
Date we don't know. 17 ಕೊಡ್ಬೋದಾ? All right, on 17th, at the request of.
Grateful, Your Honor.
Allowed serial number 6, Your Honor. Appear for appellants, Your Honor.
Which one?
Serial number 6, Your Honor.
6.
Kindly seeks for week time, Your Honors.
My lords, there was an interim order in this matter.
Wait. It's an orders list. Wait. Yes, start.
If just I entered appearance last week, maybe had next week, we're collating documents and we'll argue the matter.
Rajesh Chandra Kumar retire permitted to retire. Next week, Hakona? Next week at the request of. Yes.
This is Supreme Court remand matter, my lord. I will compile the office of rejection in the course of the day, my lord.
But ಮೂರ್ ಸರಿ ಮಾಡಿಲ್ಲಲ್ಲ.
ಇಲ್ಲ, ಅದು ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ ಬಂದಿದೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರಿಮಾಂಡ್ ಮ್ಯಾಟರ್ ಪೇಪರ್ಸ್ ಇರಲಿಲ್ಲ, ಅದನ್ನು ತರಿಸ್ಕೊಂಡಿದ್ದೇವೆ. ಐ ವಿಲ್ ಡೂ ಇಟ್ ಇನ್ ದ ಕೋರ್ಸ್ ಆಫ್ ದಿ ಡೇ.
Compliance to be done within 3 days, willing which appeal stands rejected. Yes.
For respondent number 3 and
Filing the submissions today, my lords. It may be taken up next week, my lords. I'll serve a copy on the other side also today.
ಅಲ್ಲ ಈಗ ನಮ್ಮ ಮುಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿಲ್ಲ ಇದು. ಹಂಗಾಗಿ ಸಿನಾಪ್ಸಿಸ್ ಕೇಳಿದ್ರೆ ಅದು ನಮ್ಮ ಇಂಟ್ರಾಕ್ಷನ್ ಅಲ್ಲಿ ಸಿನಾಪ್ಸಿಸ್ ರೆಡಿ ಆಗ್ಬೇಕು. ಆ ಹಿಂದಿನ ಜಡ್ಜ್ ಮುಂದಾಗಿತ್ತಾನ ಇದು ಅಲ್ವಾ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ಮೇಲೆ ಹಾಕಿ ನೋಡಮ್ಮ. Comply requirement of synopsis is dispensed with for the time being. Okay.
May be taken up for
Today.
next week or week after.
2017 matter.
We'll complete it, my lords. Submissions are also ready.
All right. Next week at the request of finally. Great. ಮೂರ್ ಸರಿ ತಗೊಂಡಿಲ್ವಾ? They have not taken. Entry ಮಾಡಿದೇನು? Yeah. Interim order stands vacated. Since opportunity given twice has not been availed and no explanation is offered for non-availment. Call after 2 weeks. I don't know, interim order dated 27/7/2021 is vacated. All right. Rest of the things as it is. Okay.
Lord, this matter can be disposed of.
Ah.
The issue is, my lord, 148 notice for reassessment came to be issued. And SSC contended, my lord, the issues on which reopening is proposed, they have already been looked into in the original assessment.
Therefore, nothing new.
Nothing, it's only a change of opinion, and the very same item has
Change
been
of
looked-
opinion is no ground for issuance of notice. How judgment?
My lord, it has,
I have held in Dharwad, na, in which you have argued. Yes. I remember, you do not. Anyway, which is that?
Well-
What?
my lord, page, para 15 of
Revenue is in appeal before this court.
my lord, page number 40.
For laying a challenge to a learned single judge's intra-court appeal and back. Revenue is in this intra-court appeal for calling in question a learned single judge's order dated 14/3/2022, whereby assessees WP number 51208 of 2019 TIT having been favored, relief has been granted to it. First off, relief portion of the order reads as under page 45.
My lord, page 40, para 15 and para 16, where, my lord, judgment of Kelvinator of India is referred to by the learned single judge.
Next paragraph. Learned senior panel counsel appearing for the appellant revenue makes vehement submission for faltering the impugned order. First off, Learned counsel appearing for the assessee per contra makes equally persuasive submission in justification of the impugned order and the reasons on which it has been constructed. Next paragraph. Having heard the learned counsel for the parties and having perused the appeal papers, we are of the considered opinion that mere change of opinion in the very same substratum is not a ground for issuance of notice of the kind for reopening of the assessment for the subject years. First off, this position has long been settled by a curtain of decisions, which need not be mentioned at all. First, the impugned order of the learned single judge is animated by such a reasoning and therefore cannot be faltered. First, next, in the above circumstances, appeal being unmeritorious is liable to be dismissed, and accordingly it is, costs having been reluctantly made easy.
May I make one submission, my lordship may kindly record also, my lord, the very same item on which it is proposed to be reopened has been looked into in the original assessment.
Sentence for him. We also notice that the items in respect of which reopening is sought to be done have already been treated by the assessing authority in his wisdom, and rightly. Okay. In the above circumstances, signs. Next. We appreciate your fairness.
Otherwise, we'll be wasting the time of the court.
In law, you are not mouthpiece of government, you are mouthpiece of law. That's all.
Appearing for the respondent.
Appear for appellant, Your Honor. Your Honor kindly seeks for a week time, Your Honor.
What is
It is
this?
Lords, there was an interim order passed wherein the appellant was directed to deposit 50% of the amount as indicated in the honorable single judge's order. So it's a refund issue wherein the honorable single judge had passed a final order in a writ petition where it was directed to pay 1.5 crores along with interest within 3 months from the date of the honorable single judge's order. Thereafter, the appellant has approached.
What is the clarification you need in respect of this? This is as clear as Gangetic waters.
It is a reallocate file, Your Honor. Must seek instructions from the department, Your Honor. Kindly have it on next Monday, Your Honor.
A short clarification is sought for as to the description of the appellants being mentioned wrongly as petitioners in the penultimate paragraph of coordinate benches order dated 2/8/2023. First stop. Next paragraph. Having seen the order and the papers, we are of the considered opinion that there is a small error in mentioning the appellants as petitioners, and therefore registry is directed to replace the word petitioners with appellants wherever it occurs in the subject order, and issue a free copy of the same if applied for. Memo disposed of. Order on memo and makes no difference.
My lords, one submission in this matter, my lord.
Next, get the request. Next.
Then
56 days delay ಇದೆ ಅಲ್ಲ ಅದನ್ನ ಕಂಡೋನ್ ಮಾಡೋಣ.
Yes, my lord. I'm okay.
ಅಲ್ಲಿ ನೋಡಮ್ಮ ಕಂಡೋನ್ IA 1 of 23 ಅಲ್ವಾ?
Yes, Your Honor.
IA 2 of 23 to be heard along with main matter. IA 2 of 2023 seeking leave to produce additional documents to be heard along with the main matter. And the respondent should be ready on that application also. Okay.
Much obliged, Your Honor.
Name of Umit Deshpande to be deleted and in his stead, all right, deleted. Okay. Call after 2 weeks.
My lords, IA-3 was filed by the appellant and interim order was granted on 2/8/2023, wherein the appellant was directed to deposit
All right, let us see
50%.
after
Within
they
4
want
weeks,
time,
my
na?
lords.
They want time. Next.
Short date, my lord.
I'll sentence clarify atala. The appellants are directed to comply with the order. Order forthwith. Okay.
Much obliged, Your Honor.
Let it be heard finally, my lord, in the
Next.
next occasion.
Don't waste time. Next.
For appellant. Lordship, the respondent has been served, my lord. I
Third.
filed the memo. It's asking officer, my lord. Affidavit also served the officing officer, my lord.
593 days.
Well, Lordship, it may be adjourned for 2 weeks, my lord. I will
But-
get some instructions, my lord, because one issue is covered against me. The second issue, the tribunal has followed the special bench decision of Hyderabad tribunal, my lord. I will just get it verified whether we have carried it to the High Court or not, my lord. Otherwise, both the questions will be covered, my lord.
Against you.
Yes, my lord. 2 weeks time may be granted, my lord.
But what about the delay? 593 days. Why government thinks that law is not applicable to it?
2 weeks time may be granted, my lord. If it is covered, my lord, I will not press.
2 weeks, finally, at the request of. Allon sir, ಹೆಸರು ಮಾಡಿ ಕೂಗ್ರಿ ಅವ್ರದ್ದು. ಅಲ್ಲೊಂದು sentence ಬರ್ಕೋಬೇಕು. Panel council submits that service is done on the respondent assessee through the assessing officer.
Yes, ma'am.
First off, name of respondent assessees loudly called out by the court officer in the open court. First off, there is no response. First off, therefore, service on them is held sufficient.
Much obliged, ma'am.
Okay. Call after 2 weeks. Finally, at the request of.
May it please, my lords.
Yes, brother.
My lords, additionally, this honorable court permitted us to take a notice on the panel council. On the very same day, we have served it on Mr. Jeevan Niralgi, who is the central.
See, Jeevan Niralgi, learned senior panel counsel, is requested to accept notice for the respondents. Petitioner to serve a set of copies.
We've already
of the
served it, my lord. 2 sets of.
appeal memo again on him and file acknowledgement in the registry within 1 week, failing which appeal stands rejected. Okay. Today, all right, within 3 days, failing which petition stands rejected.
That's been done today, ma'am.
Needfully
In the
stated to
process.
have been done this day. First off, registry to verify. If not done, post this matter for dismissal. Yes.
So, Lordship, I will compile it within the course of the day.
3 days. ಅಲ್ಲಿ ನೋಡಮ್ಮ 3 days ಅಂತ ಎಲ್ಲೆಲ್ಲಿ ಕೊಟ್ಟೇವಲ್ಲ ಫೇಲಿಂಗ್ ವಿಚ್ ಡಿಸ್ಮಿಸಲ್. ಓಕೆ.
12 and 13 also.
ಇದು 4 ಟೈಮ್ ಇದೆ. 4 ಟೈಮ್ ಹಂಗೆ ಹೋಗಕ್ ಬರಲ್ಲ.
I will
ಏನಾರ
do
ಒಂದು
today
ಕೊಡಬೇಕು.
only. Today only I will.
Don't say all that. We don't listen to the stories. Give book. Give book. No stories.
13, I appear for the respondents, my lords. We
Ah.
accept notice.
Which book you want?
Serial number 13, my lords.
13, it is await notice.
Await notice. All right.
Appeal waiting for.
11 and 12 ಆಯ್ತಾ. 12 ಅಲ್ಲಿ you have to give a book. No free thing. We don't like it.
Yes, no, I will give.
Which book you want to give? ಯಾವ್ದಾರ ಒಂದು ಒಳ್ಳೆ ಪುಸ್ತಕ ಕೊಡ್ಬೇಕು. ಹಂಗೆ ಪುಕ್ಕಟೆ ಟೈಮ್ ಕೊಡು ಅಂದ್ರೆ 3 ಸರಿ 4 ಸರಿ ಮಾಡ್ಕೊಂಡು ಇಲ್ಲ ಒಂದು 5,000 ರೂಪಾಯಿ ಇದಕ್ಕೆ ಕೊಡ್ರಿ.
ಇಲ್ಲ,
ಅಲ್ಲಿಗೆ
ಇಲ್ಲ, Lordship,
ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅಥಾರಿಟಿ ಕೊಟ್ಬಿಡಿ.
I will book ಕೊಡ್ತೀನಿ. Which book you Lordship suggestion?
ಹೇಳಿ ಒಳ್ಳೆ ಬುಕ್ ಯಾವ್ದಾರು ಒಂದು ಸಜೆಸ್ಟ್ ಮಾಡ್ರಿ.
13. Sorry, sir.
Law and lawyers reasoning.
Religion and law by justice.
Religion and law by
Religion and law
ಯಾರು?
by Justice V.R. Krishna here.
Religion and law.
I'm just reading it now. So
ನೋಡಮ್ಮ, ರಿಲೀಸನ್ ಲಾ ಅಂಡ್ ರಿಲೀಸನ್ ಅಲ್ವಾ ಅದು?
he's comparing it.
ಆ ರೀತಿ ಇದೆ, ರಿಲೀಸನ್ ಅಂಡ್ ಲಾ ನೋಡ್ಕೋಬೇಕು. By Justice Krishna Iyer, 2 copies to be submitted to the Advocates Association in the court, in the trial court, Bangalore. I'll call after 2 weeks, reluctantly call after 2 weeks. Okay, 2 weeks granted reluctantly for compliance, subject to condition. Yes, for the structure matters. Everything. Okay. 13. Then wait, you appear for respondent.
Respondent.
Narendra Kumar J. Jaina, J. Jain, learned advocate, accepts notice for the assessee.
Copies
Registry
made
to
is
print
for
his name. Okay. Yes. Three times. Madhusudan.
I'll comply within a week's time, my lords.
Give one good book, 2 books
My lords,
to the library. Yadu.
Mankutti Manakaga by
Mankuti Manakaga yaru adalla enta avardu.
Avaranna by SL.
Huh?
Avaranna by SL Bhairappa.
Avarana alladu. Avarana.
Avaranna by.
Avarana, 3rd copy by SL Bhairappa. Read that good book, it's wonderful. Yes.
1 week's time. I'll comply with-
Two books to library, Carrigan Library. Yes.
Within a week's time, I'll come.
We'll give 2 weeks for a bit. Next.
Great.
15, 16, 17 are connected matters.
Ah.
I will do it today only. Only I has to be filed.
ಇರ್ಲಿ, ಅದು 3 ಸರಿ ಬಂದಾಗಿದೆ ಇಲ್ಲ ಈಗ, ಅದು ಆ ರೀತಿ ಹಂಗ್
3 days ಅಂತ ಹೇಳಿದ್ರೆ connected. ಬೇರೆ ಮಾಡಿ.
3 times ಬಂದಿದೆ. ಈ ರೀತಿ ಮಾಡಿದ್ರೆ ನಾವು ಒಂದು 20,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಹಾಕ್ತೇನೆ ನಿಮ್ಮ ಮೇಲೆ. ಯಾಕಂದ್ರೆ ಎವ್ರಿ ಟೈಮ್ ಇದ್ ಮಾಡ್ತಾ ಅಂದ್ರೆ ಕೆಳಗ್ ಬಂದಿದ್ ಮಾಡಬಾರ್ದು ಅಂತಿದೆ ಅನ್ನೋದು.
ಇಲ್ಲ.
ಮತ್ತೆ ಅದ್ರ ಸಲುವಾಗಿನೇ ಕೊಟ್ಟಿದ್ದದು ರೂಲ್ ನಾವು ಅಮೆಂಡ್ ಮಾಡಿದ್ದು. ಐ ಆಮ್ ಎ ರೂಲ್ ಕಮಿಟಿ ಮೆಂಬರ್, ದಟ್ ಈಸ್ ದ ರೀಸನ್ ವಿ ಅಮೆಂಡೆಡ್ ದಟ್ ರೂಲ್. ನೀವು ಬುಕ್ಸ್ ಕೊಡ್ಬೇಕು, ಹಂಗೆಲ್ಲ ಪುಕ್ಕಟೇ ಇಲ್ಲ ಇಲ್ಲಿ. ನಥಿಂಗ್ ಫ್ರೀ. ನಥಿಂಗ್ ಫ್ರೀ. ಹೇಳಿ, ಒಳ್ಳೊಳ್ಳೆ ಪುಸ್ತಕ ಹೇಳಿ.
ರಾಮಾಯಣ ದರ್ಶನ.
ಕುವೆಂಪು ನೋಡಮ್ಮ, ರಾಮಾಯಣ ದರ್ಶನಂ ಒಂದು, ಅದರಲ್ಲಿ ಒಂದರಲ್ಲಿ ರಾಮಾಯಣ ದರ್ಶನಂ, ಇನ್ನೊಂದು
Matters ಎಲ್ಲ
ಜನಪ್ರಿಯ ರಾಮಾಯಣ ಬೈ ಕುವೆಂಪು. ಆಯ್ತಾ? ಆಮೇಲೆ ಇನ್ನೊಂದು 3ನೇದ್ರಲ್ಲಿ ಕುವೆಂಪು ಅವರ ಪಾದ್ರಿಯ ಮಗಳು. ಕೊಡ್ಬೇಕು, 3 ಇದಾವ್ ಎಲ್ಲ, ಅದ್ರ ಅವು 2 ಕೊಡ್ಬೇಕು. ಜನಪ್ರಿಯ ನಾರಾಯಣ 2, ರಾಮಾಯಣ ಮತ್ತು ಪಾದ್ರಿಯ ಮಗಳಿದಿಲ್ಲ ಅದು 2. ಓಕೆ, ಚಿಕ್ಕ ಪುಸ್ತಕ ಅದು. ರಾಮಾಯಣ ದರ್ಶನ 1. ನೆಕ್ಸ್ಟ್ ಮಹಾಕಾವ್ಯ, ಅದು ಕುವೆಂಪು ಅವರು ಬರೆದಿದ್ದು. ಎಸ್.
Lords, in this matter, the questions which arise have been decided by this honorable court in some cases, one of which is pending before the honorable Supreme Court and is listed tentatively for final disposal on next week.
Next week.
Please, my lords.
It may be adjourned for 3 weeks.
3 weeks.
Maybe 3 weeks.
Call after 3 weeks as requested at the bar, on the ground that similar question is being debated on the floor of the apex court of the country. First. All right, next.
For time being, it may be dispensed. Filing of submissions may be dispensed with.
ಅದೇ ನೋಡಮ್ಮ, ಫೈಲಿಂಗ್ ಆಫ್ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಡಿಸ್ಪೆನ್ಸ್ಡ್ ವಿತ್, ಅಲಾಂಗ್ ವಿತ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್.
Citation.
ಎಂತది ಇದು? ಹಂಗೆ ಇದು ಆರ್ಡರ್
Please, my lords, that was the order passed on last occasion.
ಡಿಸ್ಪೆನ್ಸ್ಡ್ ವಿತ್.
On my part, it has been filed.
ರೂಲಿಂಗ್ಸ್ ಅನ್ಬೇಕು, ಡಿಸಿಷನ್ ಅಂತ. ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕು ಅಂದ್ರೆ ಏನಾದ್ರು ಅಲ್ಲಿ ಕೆಲವು ದೇಶದಲ್ಲಿ ಡ್ರಾಫ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕುವ ಪ್ರಾವಿಷನ್ ಇದೆ. ಲೈಕ್ ಡ್ರಾಫ್ಟ್ ಇಶ್ಯೂಸ್ ಇದೆ ಅಲ್ಲ, ಹಂಗೆ ಯು ಕ್ಯಾನ್ ಫೈಲ್ ಡ್ರಾಫ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್. ಆ ರೀತಿ ಇರೋದು ಅಂದ್ರೆ ಆರ್ಡರ್ 37 ರೂಲ್ 234 ಆಫ್ ದಿ CPC ಸಮರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಾಗ ಮಾತ್ರ, ಸಮರಿ ಸೂಟ್ ಅಲ್ಲಿ ಏನ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಅಂತಾರ ಹಾಕಬೇಕು. ನೆಕ್ಸ್ಟ್ ಪ್ಲೀಸ್. Yes.
In this case, my lords, Sumana Naganand will accept notice for the sole respondents. For await.
Srimati Sumana Naganand, learned counsel, accepts notice for respondent assessee. Please, assessing.
My lord,
All-
92 days delay is there.
Huh?
92
No,
days
let
delay.
notice be served, let us consider.
90 days.
So let us file our formal objections. We have no
All right, call next week.
grateful.
ನೋಡೋಣ ಅವ್ರ ಕೇಸ್ ಬಂದಾಗೂ ಅಂತ ನೆನಪಿರ್ತದೆ ನನಗೆ. ವಿಲ್ ಡೂ ದಟ್. ಎಸ್.
My lords, I may be permitted to serve on the state government council R2 and R3, my lord.
ನೀವು ತೊಳಿ.
Yes, my lord.
Learned AGA Aditya is requested to accept notice for respondents 2 and 3.
Obliged.
Copy kodi.
Obliged. I'll give the.
The
By end of-
petitioner to furnish copies of paper books and file acknowledgement in the registry within 3 days, failing which interim order is enalli.
Illa.
A petition stands rejected. Yes. British ಇದ್ದಾರೆ ಸಾಮಾನ್ಯ ಮಿಸ್ ಮಾಡಲ್ಲ ಅವರು. ಪಾಸ್ ಓವರ್. ಈ ಕಡೆ ಬನ್ನಿ. You have to request Chandini to raise her voice.
Last date of hearing,
Make use of the mic.
on the last date of hearing, my lordship has directed to produce the gift deed, my lordship, because he is relying upon the gift deed
Ah,
that has not yet been yet produced here.
you are right. Pass over.
The learned single judge has followed its earlier order passed in the case of one Begur, my lord. That judgment has been challenged before this honorable court in division bench, my lord, in writ appeal number 568 of 24. This may be clubbed along with that, my lord.
Call this matter along with the writ appeal number so and so, so and so. Okay, our judgment, no? That
Yes,
itself is in charge.
Yes, my lord.
All right.
My lord, copies may be served in 568.
I will serve the copy, my lord. In 568 connected matter, I will serve the copy, my lord.
Copy ಕೊಡ್ಬೇಕು.
Please.
Okay.
Obliged.
For the appellant in this matter.
Ah.
My lord, this matter pertains to that post GST, pre GST, that
Ah.
contracts, my lord. The batch of matters it may be connected along with batch of matters.
Call
which is
this
already
matter
pending.
along with so and so. ಅದ್ರಲ್ಲಿ ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿದೆನಾ?
ಅದ್ರಲ್ಲಿ ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿತ್ತು. ಇಟ್ ಹಸ್ ಬಿನ್ ನೌ ಅಡ್ಜರ್ನ್ ಬೈ 2 weeks.
ಕಾಲ್ ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ಮಾಡ್ಬಿಡಿ. ಬರ್ಲಿ. ಬಿ ರೆಡಿ. ಅದರಲ್ಲಿ we have read that.
Yes.
Yes. Vishal Tiwari. Mr.
Amount
Holla?
is small.
Huh?
Amount is small. What has happened is
Ah.
Cadbury chocolate is sold by my lord the retailer.
Have you brought Cadbury? As a young boy, I was very fond of Cadbury and Lint.
All of us were, my lord,
Linte chocolates of Switzerland.
we were all, my lord, fond of it when we were
That's
kids.
what-
And during those years, only Cadbury was available. Lintu
That's
illa.
That's
ಈಗ-
Lint ಇತ್ತೀಚೆಗೆ ಬಂದಿದ್ದು.
ಈಗ Lintu ಎಲ್ಲ ಬರುತ್ತೆ ಈಗ.
That's true. That's
We went for a cinema on Friday evening when senior was there. We would all get one packet of nutties birthday.
true. So you prescribe him unless you bring that. Now you cannot argue.
Incentive was senior to conference Friday, just after court itkolade. He will take you for a cinema.
Yes, sir. What is this matter, Mr. Holla?
My lord, the second respondent before your lordships
Ah.
sold, my lord, Cadbury chocolate. He is a retailer. First respondent, my lord, is supposed to have purchased it. He, my lord, lodges a complaint saying that the chocolate is damaged. The complaint, my lord, my lords get that at running page, my lord, 83. 83.
Batch number K91013, so and so.
It is damaged, Andrew. If your lordships come to my lord, the last paragraph, para 4. On that on the same day, after taking the items to his house, it was noticed that one chocolate item damaged.
How many he had bought?
4. One is damaged. ಅಂದ್ರೆ ಅವನು ನಾವೆಲ್ಲ ಕೊಟ್ಟಿದ್ದು ನಾವು ಮ್ಯಾನುಫ್ಯಾಕ್ಚರ್ ನಮಗೆ ಇದಕ್ಕೂ ಸಂಬಂಧವೇ ಇಲ್ಲ.
Mostly Donag versus Stevens ಅಂತ ಬಂದಾರ.
ಅದು ಬರೋದಿಲ್ಲ ಇಲ್ಲಿ ಯಾಕೆಂತಂದ್ರೆ ಅದರಲ್ಲಿ What happened was, my lord, the manufacturer defect ಆದ್ರೂ ಇತ್ತು.
This is not, storing defect of the retailer.
Absolutely. ಇದ್ರಲ್ಲಿ ಏನೂ ಇಲ್ಲ. ಆಮೇಲೆ, lord, in the evidence, he, my lord, dilates and he says, ಅದರಲ್ಲಿ weight ಕಡಿಮೆ ಇತ್ತು, ಅದರಲ್ಲಿ ಲೆಂತ್ ಕಡಿಮೆ ಆಯ್ತು, ಅದು ಎಲ್ಲಿಂದ ಹೆಂಗ್ ಲೆಂತ್ ಕಡಿಮೆ ಆಗುತ್ತೆ ಗೊತ್ತಿಲ್ಲ. Trial court, my lord, consumer forum says, now, my lord, evidence ಇಲ್ಲ ಕರೆಕ್ಟ್, ಅವನು ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಆದ್ರೂ ನಾನು ಐ ಆಮ್ ಗಿವಿಂಗ್ ಡ್ಯಾಮೇಜಸ್. my lord, my problem is
ಎಷ್ಟು
not
ಅಮೌಂಟ್ ಮಾಡ್ಯಾರೆ, ಅದು ನಿಮ್ಮ ಗುಡ್ ವಿಲ್ ಪ್ರಶ್ನೆ ಬರ್ತದೆ
ಅಷ್ಟೇ. ಅದಕ್ಕೆ ಇಲ್ಲದೆ ಇದ್ರೆ, my lord, in fact I was telling them, ಸುಮ್ಮನೆ ಯಾಕೆ ದುಡ್ಡು ಇಲ್ಲ, ಇಟ್ಸ್ a matter of our, my lord, reputation. ಅದು ಇವತ್ತಿನ ದಿವಸ ಚಾಕ್ಲೇಟ್ಸ್, my lord, the variety is so much, competition is so much, rivals.
Emergent notice, interim order as sought for till next date of hearing. Alle producer is the liability of the producer is liable to the ultimate consumer principle illa no illi illa.
ಯಾಕೆ ಅಂತಂದ್ರೆ
ಬಹಳ ಪಾಸಸ್ ಅದು ಸ್ಟೇಜಸ್ ಅನ್ನು ಮೂವ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟು.
ಕರೆಕ್ಟ್. And, my lord, there must be some, my lord, evidence. ಏನೂ ಇಲ್ಲ. He says damages, ಏನ್ ಡ್ಯಾಮೇಜ್? Nothing.
When I read yesterday, I felt
ಗೊತ್ತಾಯ್ತು ಇದೇನಪ್ಪ 10,000 ರೂಪಾಯಿ ಕೇಳಿದ್ದಾರೆ ಇವರು.
But that's not Lord Lindley judgment ಇದೆ. Lesser the amount of check, greater is the loss of reputation in the case of dishonor.
Absolutely. ₹1 ಹೋಯ್ತು, ಬುದ್ಧಿನೇ ಇಲ್ಲ ನೋಡಿ ಅವನಿಗೆ, ಅವನ ಕ್ರೆಡಿಬಿಲಿಟಿ.
Yes, Mr. Mali Patil is not coming to our court, avoiding our court or what? What is this matter?
There is one more writ petition is filed by the respondent number 3 that may be clubbed together, my lord. That is
call this matter along with
FR number WP 4423.
FR number,
Oh yeah. 44 WP 4423/2025.
ಕೊಟ್ಬಿಡಿ.
ಕೊಡ್ತೀನಿ.
ಯಾವಾಗ ಬೇಕು ನಿಮಗೆ?
Next week.
Next week, okay.
These matters are admitted, my lord, maybe posted for final hearing.
Admit ಆಗಿದೆ already. ಆಗಿದೆ. Since matter is stated to have been admitted, post for hearing. Okay.
Similarly, cell number 41 also similar case.
ಅಲ್ಲೂ ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ?
41, yes.
41 ಸೇತ್ ಹಂಗೆ ಮಾಡ್ಬಿಟ್ಟು 41 ಆಗ್ಬೇಕು.
Here for the respondent.
Yes, sir. How are you?
Grateful to your lordship.
Yes. Good.
You know, this matter your lordships may recall. The question relates to this topic. What has happened is under the VAT Act, there is a notification. If your lordship see section 4.
ಏನದು briefly ಹಂಗೆ make a brief statement, Brandy statement in American jurisprudence.
Yes. What has happened is
Justice Brandy was a great judge of America and he was a great lawyer also.
the rates of tax.
Louis Brandeis.
Rates of tax are prescribed under section 4 of the Act. Under that
Section 4 prescribes it's a charging section also.
Charging section is section 3, madam.
3. 4 prescribes the rates.
Yes.
At which levy to be made.
Yes, madam.
Yes.
Charging section, levy of tax is under section 3. And liability to tax and rates thereof are section 4, my lord.
Okay.
Now, what happens, my lord, is that with respect to certain goods that are covered by 41B.
41B.
A separate schedule is prepared. By notification, a separate schedule is prepared.
41B is relatable to schedule.
Yes, ma'am.
Items are alterable by the government of the day.
Yes, ma'am.
To the schedule.
Yes, ma'am.
Okay.
On 23/3/2025, a schedule is, a notification is promulgated. 23/3/2005. My apologies.
under ordinance. Notification.
Notification.
Notification. In terms of which, under entry 15.08 Of schedule of the notification of in entry 15.08. 08. 15 is a genus, 08 is species. Yes, these come from the Central Excise Tariff Act. The classification comes from the Central Excise Tariff Act. Yes. There is an entry, my lord: animal or vegetable fats boiled, oxidized, dehydrated, sulfurized, brown, polymerized by heat and vacuum, or otherwise chemically modified, inedible mixtures of preparations of fats of oil and of chapter 15 of the Central Excise Tariff Act. There is a lower rate of tax that is given in terms of a particular item. Yes. Which is mixed with the inedible items. Yes. And new commodity comes into being. Yes. Okay. Yes. This notification, my lords, is short-lived in that it is superseded on 30/4/2005 itself. One ತಿಂಗಳು 7 ದಿವಸ ಇತ್ತು ಅಷ್ಟೇ. ಹೌದು. This superseded notification is FD 197 dated 34/2005. Otherly, the superseded the notification which supersedes is 34/2005. It comes into effect on 1/5/2005 and the entry is modified. The width of the entry is completely changed. Okay. The contention, therefore, my lords, is that for 1 month odd, the whipped cream topping was covered by the notification, thereafter ceased to be covered by the notification, and therefore moved to the residual entry. Ceased to be covered by notification may not be the correct terminology, because notification itself has gone. Yes, ceased to be covered by the new notification. Ceased to be covered by the new notification. Okay. Therefore, my lords, what happens is that it moves to the residual entry.
Since it does not fit into the new
Exemption.
superseding notification,
Yes,
goes to the residuary entry.
residuary entry. That residuary entry, the tax keeps changing as per
Slab kadme, rate kadme irtade.
rate card. ಅದು 4% ಇಂದ 100% ಹೋಯ್ತು.
Variable ಅದು.
Yes, ಆ 100% is the residual entry. Otherna government may make it in the budget, it may make it 12.5%, 13.5%, 15% from time to time. Now that is what, if your lordships are kind enough to take the petition, my lords, there is a clarification of the commissioner under section 15.
27/5/2010.
Yes, my lords. Please, my lords. It is on page 46.
Correct.
So he describes, my lords, that non-dairy whip topping is liable to tax as an industrial input from 1/4/2005 to
4%.
at 4%. Thereafter, when the second notification, which was dated 34, but comes into effect from 1/5, it moves to the residual entry.
ಅಲ್ಲ 1/4/2005 ಅಂತ ಹೇಳ್ತಾರೆ. From ಆ ಡೇಟ್ ಯಾಕೆ ಹೇಳ್ತಾರೆ ಅವರು?
ಅದು 23/3 is date of the notification. It will come into effect on 1/4.
ಆ ಡೇಟ್ ಇಂದನೇ.
ಹೌದು.
Okay.
1/5, it goes to the, for all practical purpose, for all effects and purposes, goes to the residual entry. At that point in time, residual entry, the rate is 12.5%. And
another date 1/4/2010 ಇಂದ 13.5 ಆಗ್ತದೆ.
because the residual entry rate itself changes.
Government changes the rate.
Government changes the rate. Now, this is merely in the nature of clarification. The change in the rate is by operation of the notification. It has nothing to do with this.
ಇದೇನು ಕಾನ್ಸ್ಟಿಟ್ಯೂಟಿವ್ ಅಲ್ಲ.
It only says law is like this.
It only says law is like this.
ಅದೆಲ್ಲಿದೆ?
It only 59.
In other words, any clarification has to be declaratory of what the law is, what the factors are.
Yes.
59, huh?
Yes. Government and Commissioner from time to time issue such orders, instructions and directions to all officers, including commercial tax inspectors.
ಅದೆಲ್ಲಿ ಯಾವ ಇದರಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ ನೀವು?
59 of the Act, my lords.
Section 59.
My apologies. After 1, my lords, may then thereafter come to 4. Commissioner may on his own motion or an application by registered dealer liable to pay tax if he considers necessary for the purpose of maintaining uniformity in the work of assessments, collection revenue, clarify the rate of tax payable under this Act in respect of goods liable to tax under the Act, and all officers and persons employed in the execution of the Act shall observe and follow such clarification. That is all there is. The clarification is in question does not operate retrospectively. It is the only question is one of the challenges was that it was
binding effect, clarification wrong ಆಗಿ ಮಾಡಿದ್ರು ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ. ಅದು still it binds the government.
It is only in the nature of a if it is wrong, no, there's no.
Because we act upon your clarification. Based upon that, it's a one ರೀತಿ tax is passed on to the other ಇದು ಅಲ್ಲ.
Absolutely.
Indirect tax ಇದು.
Indirect tax.
ಹೌದಲ್ಲ?
Is passed.
ಮತ್ತೆ ಅವಾಗ clarification ನಿಮ್ಗೆ ತಪ್ಪಾಗಿ ಕೊಟ್ಟಿದ್ರಿ ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ. We act upon the dealer acts upon that.
Dealer act.
He fixes the commodity, rate of the commodity, price of the commodity, and sells that. If it is wrong, it is wrong. How can he be made live? I'm just asking.
Absolutely. Which my submission.
It's a binding statutory clarification.
My submission, therefore, my lords, is that the clarification for all intents and purposes can be ignored. This is not a case that is standing on the legs of the
clarification at all, but on the law.
If the clarification is wrong, if it does not fulfill its purpose of easing the administration of the Act, it can be quashed. It can
read 59.
My lords.
Let us see the text of 59.
My lords.
Government Commissioner may from time to time issue such orders, instructions, directions to all officers, including those employed in the execution of this, as they may deem fit for the administration of this, and also observe and follow such orders, instructions. Clarification on a word in illa nilli.
It is there in 4.
4 nalli. The generality of the following part, Commissioner may on his own motion on application by registered dealer expedience for the purpose of maintaining uniformity of assessment collection of clarify the rate of tax payable under the respect of goods liable to tax under the Act, and all officer persons employed in the execution of it shall observe and follow such a clarification. Application shall be entertained. All officers and persons employed in the execution. Assessee illa. Assessee illa. Suppose you apply and you get the clarification, still you are not bound by that.
I can challenge the correctness of it because my assessing authority would be bound by the clarification.
Because
since he is an officer instituted under the Act. However, clarifications are not binding on tribunals and courts.
That the section itself says, and that is trite.
That is trite.
It will be far from therefore, my lords,
approach of the tribunal in assessing the correctness of the clarification, saying that it operates retrospectively, hence it ought not to have been acted upon, my lords. I am at your lordship's threshold, questioning that. The matter I will sink or swim on the notification dated 23/3/2005 with effect from 1/4/2005 to 34/2005, and the change in law which comes on 34/2005 effective 1/5/2005 and thereafter. So I am not on the clarification at all. The approach your lordships will see is therefore tribunal is not bound by
Tribunal is not bound at all.
adjudicatory bodies are not bound by,
Not bound at all.
because they will decide what the law is.
Precisely. Precisely. So the short question that your lordships are requested to go into is whether the whip topping comes within the new notification, which was in effect from 1/5/2005. The clarification can be
Ignoring the clarification.
ignoring the clarification. Because if it is not covered by the clarification, it is in the residual entry. Residual entry rate changes from time to time. That is all there is.
ಅಲ್ಲಿ ಟ್ರೈಬ್ನಲ್ ಏನಂತ ಹೋಲ್ಡ್ ಮಾಡಿದೆ ವಿತ್ ರೆಟ್ರೋಸ್ಪೆಕ್ಟಿವ್ ಇಫೆಕ್ಟ್ ಮಾಡಕ್.
It says, and therefore says it is wrong.
Generally, the idea of clarification is declaratory
Well,
of what is what.
your lordships may kindly say page 29. Where the prayer is made. Therefore, it is submitted that the authority under 59(4) of the Act cannot make clarification with retrospective effect, and said clarification cannot be made applicable for tax periods. And then your lordships may see at page 58.
So this runs to the idea of clarification itself. Clarification is as to what is existing position of taxability, levy, rate, etc. ಅಂತ ನೀವು ಹೇಳೋದು.
Yes. Then my lords may see how the tribunal
how this question is considered by various high courts in the country or other courts of the other foreign courts, how this idea is treated. Not that for the first time it has come before our court.
I'll take your lordships through the treatment by the tribunal, my lords, then I'll address page 58, my lords, para 43. Moreover, as already observed, non-dairy whip topping is considered as industrial inputs by the Learned Commissioner of Commercial Taxes in clarification number so and so 27/5/2010. In terms of notification dated FD CSL 2005-8 dated 23/3/2005. This, my lords, has been superseded. I will, your lordship's book also, it will be there. But if a copy comes, I'll. But there is no basis for Learned Commissioner of Commercial Taxes to clarify the rate at 12.5% from 1/5/2010 to 33/2010, 2005 to 33/2010, and the rate of 13.5 from 1/4/2010, because government of Karnataka neither increased the rate of tax nor treated the non-dairy whip topping.
This is wrong.
This is wrong. Because of the new.
During that period, it was government had changed it.
Yes, because of the new
matter of notification.
It's a matter of notification.
And every notification is a subordinate legislation.
Precisely. Precisely. And this is my submission for admission. Your lordships may see the notification is serial number 22. Sir, I have a book code flag mark. I should have got a copy. My apologies, my lord. I don't know why.
Oh, no.
I asked for a copy, then I was told it is 60 pages. This approach of the government is penny wise pound foolish.
Found foolish. Found foolish or found foolish? Both perhaps.
Entire notification is read. It will make things amply clear, my lord. For example, if your lordship were to turn to page 44, the order of the tribunal starts at page 14. The tribunal has reproduced both the notifications. If your lordship sees the first notification.
If my, I'll just point out the supersession and then my senior friend can.
ಆ ನೋಟಿಫಿಕೇಶನ್ ಇದರಲ್ಲೂ ಇದೆ, ಆ ಆರ್ಡರ್ಸ್ ನಲ್ಲೂ ಇದೆ.
Reproduce ಮಾಡಿದ್ದಾರೆ.
ಈ ಆರ್ಡರ್ ನಲ್ಲಿ ಇದ್ದಿದ್ದು ಸರಿ ಇಲ್ಲನು?
ಇಲ್ಲ, ಇದು ಕಂಪ್ಲೀಟ್ನೆಸ್ ಗೆ. In exercise by powers conferred by clause A of so and so of the third schedule of the Karnataka VAT Act and in supersession of notification FD 55 CSL 2005-8 dated 23 March 2005, Government of Karnataka hereby specifies with effect on the date of 1st May 2005, goods specified in column 3 of the table below, specified in the so and so.
Item number?
Alilla.
Adralilla.
Adralilla. The
ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ನೋಟಿಫಿಕೇಶನ್ ದಲ್ಲಿ ಇಲ್ಲೇ ಇಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲ.
It is absent.
It is absent.
That goes against you.
No. If it is not there, it moves back to the
ರೆಸಿಡ್ಯೂವರಿ ಹೋಗಿಬಿಡ್ತದೆ ಅಂತ. ಅಲ್ಲಿ ರೆಸಿಡ್ಯೂವರಿಗೆ ಹೋಗತ್ತೆ ಅನ್ನುವಂಥ ಸೆಕ್ಷನ್ ಯಾವುದು?
ಅದು 4.
4.
Your lordships may come to section 4. One B. Every dealer who is or is required to be registered as specified in sections 22 and 24 shall be liable to pay tax on his taxable turnover. In respect of goods mentioned in second schedule, 1%, third schedule, 5.5%, fourth schedule, 20%. Then your lordship may come to B. Declared goods as per section 14 of Central Sales Tax Act, which is the 1956 Act, maximum rate prescribed at such goods under section 15 of the Act. Cigarettes, so and so at 20%. Other goods at the rate of 14.5%.
The other goods,
other goods.
For 1B3.
Yes. Yes. Now, if I am to succeed, I will be able to show your lordships that what was there in 23/3/2005 notification is not there in.
Then it goes to residuary.
If my senior friend is to succeed, he will show that notwithstanding the supersession, it continues in some entry or the other, it continues to be found. And that, my lords, I respectfully submit, is a matter of interpretation of the law, and hence I am seeking admission. The clarification I am not standing on at all.
ಯಾವ year matter ಇದು?
23.
9, 10, 10, 11.
No, sorry,
Assessment.
The tax period is 9, 10, 10, 11. Much after the.
In 2016.
Idu the STA before the tribunal will be 2016.
ಆ ರೀತಿನಾದ್ರು ಇನ್ನಂತ
STR.
The
STR tax appeals.
ಅದು there is the ಇಷ್ಟ ಇದೆ ಇದು. ಇದನ್ನೇನು ಅಡ್ಮಿಟ್ ಮಾಡೋದು ಏನು ಬಂತು, ಇದನ್ನೆಲ್ಲ ಹಿಯರ್ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡ್ಬೋದು. ಎಲ್ಲರಿಗೇನೋ ಒಂದು ಸ್ವಲ್ಪ ಚೇಂಜ್ ಆಫ್ ಲಾ ಇದೆಯಲ್ಲ, ಮೊದಲಿಗೆ ಅಡ್ಮಿಟ್ ಮಾಡಿ ಆಮೇಲೆ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಫ್ರೇಮ್ ಮಾಡಿ ಹೆಂಗೆಗೋ ಇದೆ ಸೆಕ್ಷನ್ ಮಚ್ ಡಿಫರೆಂಟ್ ಫ್ರಮ್ CPC. Other day you read that, na?
Yes, yes.
We
Yes.
treated one matter like that.
Yes, my lord. Yes, my lord. Yes. The admission is a tripartite affair.
Bit different from our CPC admission. All right. Is there in case, sir?
There are some judgments on what exactly this whip topping is. If your lordships are hearing it finally, then naale adre I can produce those judgments also. I have copies.
Lord, before I take your lordships to the order passed by the tribunal, may I invite my lord's kind attention to section 65?
ಅಲ್ಲ, ಹಿಯರಿಂಗ್ ಈಗ ರೆಡಿ ಇಲ್ಲ ನೀವು
ಮಾಡ್ಬೋದು,
ಮಾಡ್ಬೋದಾ?
ಮಾಡ್ಬೋದು, ನೋ ಪ್ರಾಬ್ಲಮ್.
ಮತ್ತೆ ನೀವು ಅದು ಯಾವ ಜಜ್ಮೆಂಟ್ ಹೇಳಿದ್ರಲ್ಲ ಅದನ್ನು ಕೊಟ್ಟು ಬಿಡಿ.
ಅದನ್ನ
ನಿಮ್ದು ಆದ್ಮೇಲೆ ನಾ ಇವ್ರನ್ನ ಕೇಳ್ತೇನೆ, ನಿಮ್ ಮುಗಿಸ್ಬಿಡಿ.
ಇಲ್ಲ, ನಾನು ಕಾಪೀಸ್ ತರಿಸ್ತೀನಿ.
ಓಕೆ, ಇನ್ ದ ಮೀನ್ ವೆಲ್ ತರ್ಸೋತೀರಾ? ಅದ್ರ ಮೇಲೆ ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ದಂಗಿಲ್ಲ.
ಇಲ್ಲ, ನೇಚರ್ ಆಫ್ ವಿಪ್ ಟಾಪಿಂಗ್ ಏನಿಲ್ಲ. Yet to see what my learned friend may go into.
ಅಲ್ಲ, ವೈಟ್ ಟಾಪಿಂಗ್ ಮೇಲೆ ಇದು ಇದೆಯಾ, ಏನಾದ್ರು ಇಶ್ಯೂ ಇದೆಯಾ? ಅದ್ರ ಮೇಲೆ ಏನಾದ್ರು ಇಶ್ಯೂ ಇದೆಯಾ?
We need not go thus far at all. I'll briefly take your lordships to the provisions of the act and how the tribunal has dealt with the matter. Your lordships will kindly see section 63 pertains to appeals to the appellate tribunal.
63 is appeal.
Appeals to the appellate tribunal. Any person feeling aggrieved by an order passed by the joint commissioner can appeal to the tribunal.
ಅದು JCCT ಆರ್ಡರ್ ಮೇಲೆ ಮಾತ್ರ. ಈ ಆರ್ಡರ್ ಯಾರ್ದು?
JCCT appeals passed the order. Feeling aggrieved, I carried the matter in appeal to the tribunal.
Right. So on that, no dispute.
Yes. Now your lordship sees section 65, my lord. Under what circumstances can a revision petition to this honorable court? Lies. Section 65 of the KVAT Act.
By High Court. In certain cases.
Within 180 days from the date on which an order under subsection so and so of section 63 was communicated to him, the appellant or the respondent may prefer a petition to the High Court against the order on the ground that the appellate tribunal has either failed to decide or decided erroneously any question of law. If the tribunal has gone into the issues and formed an opinion on facts, challenging the correctness of the order of the tribunal,
no revision.
No revision petition lies.
How this idea of question of law treated by the courts?
Yes. Now your lordship sees, let us first examine, my lord, what is it that the tribunal was answering and how did they go about the procedure of answering the said question?
No, we want to know.
Lordship.
What is that idea of question of law? Because someone treats what's a question of law, question of fact, question of opinion, question of discretion. His idea is any question which can be answered by turning the pages of the book, law book, is a question of law. But we have not adopted it.
Yes.
In 2-3 judgments which together we have read,
Lordship.
rendered.
Yes.
It is a larger idea is our end. Therefore, we want to know.
Lord, to put it in one sentence, question of law when you state is different from an answering on the aspects of facts. Because that would be on facts and not on law. A question of law that arises is something that is capable of being interpreted judiciously, where possibly there could be more than one degree of interpretation that stands warranted to a particular phrase. Then a question of law would arise. But on a fact, what is it that the tribunal was called upon to examine, and whether that decision which the tribunal came to was erroneously answered, then a revision petition would lie. Or if the question of law that fell for consideration was erroneously answered, again a revision petition would lie. Now let us see, my lord, how the tribunal went about the exercise.
But we are not in agreement with your restrictive argument.
Lordship.
Law says, a curtain of judgments, they say, a question of law will arise where a finding is recorded in the absence of evidentiary material.
Yes.
Or a finding is recorded contrary to the evidentiary material.
Question of law arises.
Arises.
I concede, I bow to that. Yes. Now your lordship sees, my lord, the order of the tribunal starts at page 14. And at page 17, paras 8. These are the questions that the tribunal posed unto itself for answering. 1. Lordship's got that, my lord? Page 17, para 8.
Whether the common appellant.
Yes, whether the common appellant has made out good and sufficient grounds, reasons to set aside the impugned common order dated so-and-so as sprayed. 2. Whether the common respondent, first appellate authority, is justified in passing such impugned common order. 3.
Ibru challenge madidru, no?
Illa, bari nan matra. Only the assessee.
These two state appeals are fit. Third question.
Whether these two ST appeals, that is sales tax appeals preferred by the assessor, are fit cases for interference by this tribunal. And then your lordship finds the answers to those questions at para 10.
Affirmative, negative.
Affirmative, negative, affirmative. Then you may straight away take your lordships to the notification that was brought out by the state at page 43. Now 44 is the first notification which my learned friend read to your lordship. Now, this was the notification that came into effect from 1/4/2005.
You're right.
And held the field until it was superseded with effect from 7/6/2005. I may be permitted to read the entire body of the notification, my lord. In exercise of the powers conferred by section 4(1)A read with entry 35 of the third schedule of the Karnataka Value Added Tax Act, the government of Karnataka hereby specifies with effect from the first day of April 2005, the goods mentioned in column 4 of the table below with heading and subheading numbers under the Central Excise Tariff Act as industrial inputs and packing materials, namely. So if I dealt with an industrial input and packing material as enumerated by the rulemaking authority, then I would be entitled to the concessional rate of tax. Now, what are the goods that came under the phrase industrial inputs and packing materials, namely? That has been set out, my lord. Your lordship gets the just below.
That's what.
Heading
Animal
number
or
50.
vegetable, etc.
It says animal or vegetable fats, boiled, oxidized, dehydrated, sulfurized, blown, polymerized by heat in vacuum or in inert gas, or otherwise chemically modified, inedible mixtures of preparations of fats and oils of Chapter 15 of the Central Excise Tariff Act, etc.
Animal or vegetable fats.
Yes.
Rest of the things are adjectives.
Yes.
Adjectives.
So, now for a moment, my lord, if your lordship turns the page to page 46, the clarification has been reproduced by the tribunal as brought out by the Commissioner of Commercial Taxes, who is the highest officer employed in the execution of the Act. This is what he clarifies. Clarification number so-and-so dated 20.
Clarified that?
Yes. It is clarified that non-dairy whip topping, that's the product which I deal with, is liable to tax at 4% as an industrial input from 1/4/2005 to 30/4/2005 in terms of the notification dated 23/3/2005. That's the notification which I just read to your lordship.
Which repeals the earlier one.
No, which stood the repeal, which stood superseded by the subsequent one. I just read to your lordship.
That is with effect from 1/4/2005. That's right.
Yes, it held the field from 1/4/2005 up to 6/6/2005.
1 month plus.
1 month plus. Now, in the background of this language employed in this notification, the commissioner clarified that non-dairy whip topping is liable to tax at 4% as an industrial input. He clarifies that the product dealt with is an industrial input liable for concessional rate of tax, but restricts it to the period from 1/4/2005 and up to 30th April 2005.
Correct.
Then your lordship sees the wordings as employed by the commissioner in his clarification. He says, I'm entitled so-and-so in terms of the notification dated 23/3/2005. That's the previous page your lordship got that notification at page 44.
No, you said as employed, you said, now where is that? It's your argument.
In terms of the notification, the previous page, my lord, page 44, the tribunal reproduced the notification. This is dated 23/3/2005, and it is brought into effect from 1/4/2005.
Correct.
So commissioner says that my product falls under this notification. If I come under this notification, then I'm entitled to the concessional rate of tax.
2005 notification.
How? 2005 notification.
For 1 month plus.
For 1 month plus.
For next, it will be 12.5.
Then let us see, my lord, what happened next. The next notification your lordship sees in the previous page, namely 43, page 43, which has been reproduced. Now, the third schedule appended to the Act has been reproduced at page 43.
You're right.
Third schedule, goods taxable at 5.5%.
You're right.
Serial number, entry number 51.
Industrial
inputs and packing materials as may be notified. Now, if I am to entitle myself to the concessional rate of tax, one, the product must be an industrial input and or a packing material. Not every industrial input and packing material would be available for the benefit of taking note of this particular notification or the entry. It is only as specified as notified. So unless and until there is a notification to back or list the items in the said notification,
this item should figure in a notification. That's all.
Yeah. If my product does not figure in the notification, I'm out of the concessional rate of tax bracket.
It will be residual.
But if I'm able to show, which I did before the Honorable Tribunal, that my product continues to be an industrial input as was notified by the state while bringing out the notification with which they were convinced, therefore they granted me the relief. Now, am I right or wrong is what your lordships are now examining. Now, if your lordships will kindly turn to page 58, 57 it starts. The notification that superseded my earlier notification.
Allah, idin ಹೇಳ್ತಾ entry number 51 ಇದೆಯಲ್ಲ, come to 43 now, which you were reading.
Yes.
Ali, as may be notified ಇದೆಯಲ್ಲ.
Yes.
Where is such notification?
Yes, that is at page 57. Paragraph 42. Thereafter, the notification dated 23/3/2005, that is what I read to your lordships, which your lordships noticed at page 44.
Which is superseded by subsequent notification.
The one that supersedes is this.
Correct.
Down below. Thereafter, the notification dated 23/3/2005 bearing number so-and-so has been superseded by the notification dated 34/2005 bearing FD number so-and-so, and it is reproduced and reads thus. Notification.
Correct.
bearing number so-and-so dated 30th April 2005. Now let us see the language employed here. In exercise of the powers conferred by clause A of subsection 1 of section 4, read with entry number so-and-so, and in supersession of notification number so-and-so, the government of Karnataka hereby specifies with effect from 1st day of May 2005, the goods specified in column 3 of the table below with heading and subheading numbers under the Central Excise Tariff Act specified in column so-and-so as industrial inputs and packing materials, namely
animal and vegetable fats, boiled,
oxidized, dehydrated, etc. That word etc., in my respectful opinion, my lord, and submission, takes the color from the notification that got superseded, which your lordships found at page 44.
Printed that one only.
Correct. That's the whole thing, my lord. If your lordship sees that notification at page 44.
Yes, I remember that. That it said so preparation of fats, oils, so and so.
It opened with the same phraseology. Animal or vegetable fats, boiled, oxidized, dehydrated. Adad Nantra, in the previous notification, they went on to enumerate sulfurized, blown, polymerized by heat and vacuum or in etc. preparations of fats and oils in chapter 15. Here what instead they do, instead of reproducing the entire entry bodily lifted from there and planted here, they use the word etc.
So in other words, this etc. should be read as if what is printed in the earlier notification is printed with invisible ink anta ನೀವು ಹೇಳ್ತಾ ಇರೋದು.
Lordship.
Difficult.
But why? I'll explain to you, Lordship. Why? But then where was the need for them to bring about that the second notification? Anta one aspect of the matter may cross the mind, man.
Etc. Apex code ordinarily applied the doctrine of adjustum generis. Number one. Number two, every notification, the apex court said in a category of decisions, every statutory notification which has got repetitive effect should be treated as a subordinate legislation. Number two. Number three, the rules applicable for interpretation of legislation shall be ordinarily applicable to interpretation of subordinate legislation.
Yes.
If intent of the rule maker was to give benefit of etc. as you now propounded before us, the rule maker would have simply printed the text of earlier notification into the superseding notification, which is not the case.
Yes. That is one view of the matter. To view it slightly different, I asked myself a question. So what should be the meaning attributed to the word etc. here? When the rule-making authority thought it appropriate not to enumerate it in detail like the one that they did in the anterior notification, what meaning is to be ascribed to the word etc.? I'll tell your lordships as to why this amendment was brought about, why a subsequent notification.
Maxwell on interpretation. Broom's legal maxim nalli ಒಂದು maxim ಅನ್ನು interpret ಮಾಡಿದ್ವಿ. Nocitur a socis. ಅದರ ಮೇಲೆ we have interpreted same thing by adopting the maxim nocitur a socis.
Yes.
Means in a company of words, a particular word would take its meaning from the rest.
Yes.
Etc. idea. It operates between nocitur a socis and adjustum generis. In between iro doctrine illa maxim nalli. Broom's legal maxims nalli illa. Therefore, I invented one particular idea long ago after I became judge in 2018. In Dharwad bench, I remember. We'll take out that judgment also. You ever ಒಂದು hybrid ಮಾಡಿದೆ ನಾನು. ಅಲ್ಲಿಗೂ ಬರಲ್ಲ ಇಲ್ಲಿಗೂ ಬರಲ್ಲ. ಅವಾಗ ಹಂಗಾರೆ ಏನ್ ಮಾಡಬೇಕು ಅನ್ಕೊಂಡು ಇವೆರಡರದ್ದು ವಿಜಿಡಮ್ ಅನ್ನು ತಗೊಂಡು ಒಂದು ಪರ್ಟಿಕ್ಯುಲರ್ ಒಂದೆಂಥದ್ದು ಮಾಡಿದೆ ನಾನು. Anyway, you make submission. Yes. Let us see.
Now the reason, my lord, why the second notification was necessitated for them to bring out.
So
If
your
the word-
gist of your submission is
Lord.
the terminology in the superseding notification should be read as having the text of superseded notification.
For a moment, if your lordship turns back to page 44, the previous entry, that is the notification which stood superseded.
Page
Haga-
44.
44.
You are right.
Your lordship sees the heading. The heading and subheading numbers are culled out from the Central Excise Tariff Act. In the superseded notification as well as the superseding notification, it is the Central Excise Tariff Act alone where the entries were borrowed from. At that point in time, the Central Excise Tariff Act had only two heading and then two subheading. That's the reason why when they reproduce those entries in the notification, they use 15.08.
Correct.
Then what happened? Central Excise Tariff Act underwent an amendment. From May 2005 onwards, 28 to 2005 onwards. Then what happened? They introduced a 8-digit system of codifying the goods which are to be found in the Central Excise Tariff Act. Now, if your lordship turns to page 58 on the other hand, in comparison with 44, page 44, now page 58, your lordship sees a 8-digit enumeration, 1518.00.40, that is heading and subheading. In order to bring the goods as found in the VAT Act in sync with the Central Excise Tariff Act and the heading and subheading, it was necessitated for them to bring out this notification superseding the earlier notification, so that the items found in the Tariff Act, Central Excise Tariff Act, where you're bodily lifting and planting them for the purposes of the VAT Act, will be in the same sync.
They would have printed it. Do you think that government does not understand language?
They should have.
They have.
They should have actually, man.
They have.
I would like to see your lordship's judgment for that word, etc., as to how your lordships have taken that particular line of thinking. My lord, may I, my lord, for a moment suggest this? Two things, my lord. Either your lordship feels the matter to be admitted, your lordship may admit, post the matter on a date convenient to this honorable court.
We have said with that impression you are arguing. We said in the beginning.
No, I would like to see your lordship's judgment.
Let us.
And I will also take out judgments as to how the courts have interpreted the word etc. In what context and in what background. Whether my argument holds or otherwise, I would like to see what the law declared by this honorable court as well as several other courts, including the apex court, have viewed on this aspect of the matter.
Matter having been heard at length is adjourned for further hearing. Tomorrow?
No, I'm not in station, madam. Starting tomorrow. 2 weeks from now, madam. Any date after 2 weeks.
Forget that. 1 week we can give, not beyond 1 week.
1 week.
Choose your day. That day you have to argue.
May I persuade your lordships to look at the notification, my lord, that we were looking at?
Superseding.
The superseding notification.
57, 58.
Yes. It will end at about page 512 of the book.
But sometimes, as Prasad said, your governments will do these things also without application of mind. Again, we can't so much presume, although I confronted him with that question to bring more material from him. But what he said has happened in number of cases. That's our experience also.
But my argument stands on 3 legs. One is, so far as the notification is concerned,
barely about 37 days later, new notification is brought into force, excluding something that was there earlier. One, number of judgments where high courts hold that whip topping is not an industrial input, which was the reason for its exclusion. And three,
share
share market.
so that he will also come in there. No, that argument, my lord, if I may be permitted to say this. The learned commissioner said my whip topping comes as an industrial input liable for concessional rate of tax for 1 month and plus days.
That particular period.
If he formed an opinion that my whip topping is an industrial input as was governed by that entry during that period, then the short point would be, what is it that got him to differ for the period subsequent to the supersession of the earlier superseded notification to form an opinion to say why whip topping cannot now come under as an industrial input?
Terminology of the province. Correct. That's your argument.
That's
the terminology of the subsequent notification. Government has taken it out of his hands. That's what. Let us see. Let's see.
No, my lord,
Not that simple. But anyway, you will also have some questions to answer. I am a generalist. I can only make simple arguments in tax.
No, but he does a good job.
It's the notification itself. But both you are doing very good job. Your goodness is our toughness now. That's our difficulty.
May I request your lordship to have it either on 18th or 19th, which is a Tuesday or Wednesday, my lord.
Whichever you want.
So, Aditya, which date suits?
I am here every day. Whichever date you want.
18th, my lord, Tuesday.
18th. Very matters is 18th, my lord. But interesting point is there.
Lord, may I have the judgment which your lordship
that also
render.
again I have to fish out from. I have given
I will take it from the
36,000
court option.
cases. As of now, I have decided 36,000 cases going by the statistical data which is furnished to us. So even I have to fish out from the memory pond. At times, fishes are not there at all in my pond. So you only have to do. But there are such
yes,
one book I will tell you, which may help you. Two books I will tell you. One is A Judge in a Democracy. Another is Purposive Interpretation of Law. Why? Same author. Justice Aharon Barak of Israeli Supreme Court. He had given idea as to how they should be. The second one is Maxwell on Interpretation of Statutes. He has said in one page about this also. The third one is Broom's Legal Maxims.
Lordship.
It fits into in between these two. One is Nocitur Esosi. Another is Agistum Generis. Between these two, there are 3 judgments of the apex court also. Just look into it.
Lordship.
GPC also has referred to that. Yes.
Oblige me.
Thank you.
So 18th, my lord.
18th. For further hearing. Yes.
The ship seal number 32, 33, 34 are all connected, my lord. Same SSC, my lord.
33, 30.
32, 33 and 34, my lord. They are all connected, my lord. Some of the issues are pending before the Supreme Court, my lord. It requires consideration, my lord.
May I just submit one thing, my lords? My lords, item number 32, ITA number 102 of 2024. There are 2 questions, both pertain to only one issue, and that has been held in my favor by this honorable court in my own case. May I just pass on the decision?
Your lordship, for that one, my lord, there is an amendment to section 36(1), my lord.
With effect from?
2014, my lord.
Covering the said period?
Your lordship, said period it is covered. This is for the assessment at 2014-15, my lord.
That was not considered by the division
not
coordinate
considered.
bench?
No, my lord. The coordinate decision, bench decision is prior to that amendment, my lord.
Which? Assessment year 2013-14.
13-14, my lord, those cases, my lord. But in present case, it is 14-15, my lord.
14-15 amendment ಆಗಿದೆಯಾ?
Amendment ಆಗಿದೆ. Your lordship, section 36(1), Roman 7.
Income tax ಕೊಡಿ.
Let's just before that, this decision that I have passed on, my lords may just see the first page, the last paragraph. This also pertains to the assessment years 14-15 and 13-14. ITA number 207 by the revenue challenging the order dated so and so for the AY 2014. And
Para?
just at the bottom of the first page here, my lords. just after the judgment heading.
Fourteen, 15 also.
Yes, my lords.
That is for 14, 15.
13, 14.
13, 14 and 14, 15. Both years,
Both are covered.
both are covered by this judgment, my lords. And what is
14 and 14, 15. Both are covered, brother.
what is before my lords today is AY 14, 15.
Your Lordship, this judgment, Lord, is decided on 5th, 2022, Lord, December 5, 2022.
Correct.
This amendment is with effect from 2001 for 2014, my Lord.
But that also
Your
must have
Lordship,
been.
that is not covered, my Lord, because Your Lordship, the Honorable Court was only dealing with assessment year 2013-14 in the first page, my Lord, before the judgment facts of the case, before the question, my Lord, the assessment year 2013-14. 13, 14, 15, my Lord.
For 14, 15. And the second one is for.
Where is the consideration of that amendment in this judgment?
My lords,
No consideration at all.
my lords, frankly, I'm not aware what amendment the learned counsel is referring
Show
to.
that, show
Yes,
that
my Lord.
amendment.
Your Lordship, section 36, my Lord. Your Lordship, page number. Your Lordship, page number 1.347. Your Lordship, section 36, my Lord, it starts with page number, my Lord, 1.342. It is relating to other deductions, my Lord. Your Lordship, subsection 7, which is at page number 1.346, my Lord.
What?
1.346, my Lord.
346. Item
Your Lordship, subsection 7, my Lord, Roman 7.
subject to the provisions
of subsection 2, the amount of any bad debt or part thereof, which is written off as
irrecoverable in the accounts of the assessee for the previous year.
Your Lordship, this is general clause, my Lord, but Your Lordship may kindly see the explanation 2, which has been amended, my Lord. In the next page.
Removal of doubts.
For the removal of doubts, it is hereby clarified that the purposes of the proviso to clause 7 of this subsection and the clause 5 of subsection 2, the account referred to therein shall be only one
account in respect of
provision for bad and doubtful debts. 8. Under the clause 7A, and such account shall relate to all types of advances, including advances made by rural branches. So, Lordship, now next to 7A. In respect of any provision for bad and doubtful debts made by a scheduled bank not being a bank incorporated by or under the laws of a country outside India, or a non-scheduled bank, or a cooperative bank, or other than a primary agricultural credit society, or a primary cooperative agricultural and rural development bank, an amount not exceeding 1.5% of the total income computed before the making any deduction under this clause and chapter 7 and the 6A, and an amount not exceeding 10% of the aggregate average advances made by the rural branches of the such bank computed in the prescribed manner. So, Lordship, there is a specific
ceiling limit
for
type of the bank
rural.
also.
Yes, Lord. So, Lordship,
bank
it is a scheduled bank, my Lord. Now, because of the amendment, my Lord, now we have to ask the authorities to re-verify whether the rural branches transactions have been involved in the non-rural branches. So, Lordship, the explanation says, my Lord, for the removal of doubts, it is hereby clarified that for the purposes of proviso to clause 7 of this subsection and clause 5 of subsection 2, the account referred to therein shall be only one account in respect of provision for bad and doubtful debts under clause 7A, and such account shall relate to all types of advances.
This has not been considered.
May I just clarify one point, my lords? Well, there are two sections that we are dealing with. The section that is relevant for my lord's consideration today is only section 36(1) subclause 7A. I will come to what 36(1)(7) deals with, but this is my first submission. Well, 36(1)(7A) deals with a case where advances are given by rural branches of a bank. Only in cases of advances made by rural branches of bank, my lords, a mere provision created is eligible for a deduction. My lords may be aware, under Income Tax Act, a mere provision is not at all allowable as a deduction. Only if you have actually incurred an expenditure, it is allowable as a deduction. But in certain circumstances where the Act itself prescribes a mere provision can be claimed as a deduction, a provision can be claimed, my lords. Under 36(1)(7A, where a bank makes advances in a rural branch, by a rural branch in rural areas, a mere provision created for bad and doubtful debts is eligible for deduction. Now, my lords, what is for consideration before my lords today is, how do you compute this deduction? Under section 36(1)(7A, what is prescribed is a certain specified percentage of the aggregate average rural advance, which is to be computed in the manner prescribed. May I just read out that section again for my
No,
lords?
but then it requires consideration.
My lords, my humble
You're not
submission.
hearing the matter now.
Well, that's my humble submission that amendment has nothing to do with this section, which is why it was not brought to the lord's attention in the previous judgment.
Because 7A are all interlinked, my lord.
Let us have the serial number. The appeal is admitted on the following question of law, substantial questions of law. Pages to the
Lordship, in page number 4, my lord. In first case, it is question 1 and 2, my lord.
1 and 2. The court adds another substantial question of law at the instance of learned counsel appearing for the assessee as under whether the fact matrix of this case is substantially similar to the one decided by a coordinate bench of this court in Commissioner of Income Tax versus Canara Bank 2023 147 taxman.com 171 Karnataka question mark. No.
Well, that was what covered. Just one submission. That decision was considered by the tribunal. That was what the tribunal followed, Malad. I just want to complete my submission.
Next. 32 admitted. Next 33. Questions have the other.
Questions as reflected in the appeal memo, my lord, at page number 4, my lord. At page number 4, my lord, all questions, my lord.
34.
Yes, my lord.
Yes.
P6, I appear with the appellant. Seek for a passover, my lords.
Passover,
please.
Please.
Oblige.
My lords. What has happened in this matter, my lords, is that the main original appeal, my lords, has been dismissed for monetary limits. But this appeal, my lords, is a consequential matter for the penalty. My lords, if the main appeal has been dismissed for monetary limit, my lords, this penalty is up to 5 crore, my lords. There's some sort of anomaly, my lords, in the matter completely. So, my lords, I'm looking for the assessment officer, my lords, to give me instructions on this after 2 weeks, my lords. Because the main appeal, my lords, challenging the assessment order is dismissed. Consequently, my lords, the penalty proceeding is 5 crore, which is beyond monetary limit, my lords. That's the reason, my lords, some sort of confusion, my lords. In fact, my lords, the main appeal was...
Monetary limit applies to appeal, only the...
Yes, my lords.
Appeals.
No.
Penalty proceedings.
No, penalty proceedings also come under, my lords. Any appeal under 260A, my lords, ML is applicable, my lords.
Amount is there.
This is 5 crores, is for me. Yes, my lords. But if the main matter, my lords, in the merits has been withdrawn or dismissed for monetary limit, my lords, the calculation does not add up. We, my lords, have read the file. Somewhere the calculation does not add up.
What do you say, madam?
Lord, submission is this way. Where the assessing officer made an addition on a certain aspect, that the tribunal gave me relief, and when that traveled to this honorable court, that was dismissed on account of monetary limits. Now, in respect of that very addition, where the tribunal gave me relief, they have levied penalty.
It cannot be.
This appeal arises out of the penalty order. My lord, so the submission is where I am granted relief on the main addition by the tribunal, whereas the
Then
question
this
of
question will not arise at all.
appeal itself doesn't arise.
That's the reason, my lords, we have spoken to the assessment officer to say, please let us clarify on this aspect.
In clarification, legal position.
No, legal
How
position is
clarify mada agatyane illa.
No, my lords, what has happened is,
Item which has been excluded by the tribunal, that is made the basis for penalty proceedings.
Yes, my
If
lords.
that is excluded by the tribunal's order, how are you how do you
My lords,
going
what
to
has happened
maintain
is,
this?
I had come in appeal of that order, my lords, before this court. But that was withdrawn, my lords, or dismissed for monetary limit basis.
Leave that apart.
My lords.
That has even otherwise you are not entitled to challenge that.
No, my lords. That I understand, my lords. That I understand, my lords. But my lords, this whether the main appeal, my lords, was beyond the monetary limit or not is something that we are checking, my lords. Because if my main matter goes away.
Liberty ಏನಾದ್ರು reserve ಮಾಡಿದಾರನು?
Yes, my lords. Yes, my lords.
ಮಾಡಿದಾರ?
Every other matter, my lords, liberty is reserved, my lords. My lords, if the main matter is still dismissed, my lords, I have no legs to stand on today. So, my lords. If on merits, my lord, if it has attained finality.
Then that would have been right, not otherwise antana.
If tribunal has held in favor of the SEC.
On merit ಮೇಲೆ hold ಮಾಡಿದ್ದಾರೆ.
And
ಅದಾದ್ಮೇಲೆ ಹೆಂಗಾಗತ್ತೆ ಇದು?
even if the appeal is not maintained, if the appeal is not maintainable on monetary limits, my lord, the issue has attained finality on merits.
That's what. Therefore, appeals have to go. That's how we have held now.
With liberty, okay. With liberty, how long 2018 ಆಗಿತ್ತು. This matter also, with liberty. This is beyond 5 crores, beyond 5 crores. It is there, but the merits is attained.
Vishal,
My lords.
ಏನಿಲ್ಲ.
My lords, may I request next Monday, my lords, because I'll just check with the assessment officer, I'll come back. If I have to withdraw, I'll withdraw, my lords. Because, my lords, this is also beyond 5 crores, my lords. That's the reason.
ಅದು ಆ ಪ್ರಶ್ನೆ ಅಲ್ಲ.
Yes.
ಆರ್ಡರ್ ಹಂಗಾಗಿದೆ. ಅದ್ರ ಮೇಲೆ ಮೆರಿಟ್ ಮೇಲೆ ಆಗಿದೆ. How we are going to, as she rightly says, you cannot maintain the appeal at all.
I'll request for Monday, my lords.
All right, call this matter on Monday for further hearing.
Yes, my lords, further.
Take fix much.
25th.
Call on so and so much.
25th. 18th.
18. All. ಅಸಿಸ್ಸಿಗೆ ಏನಾರ ಒಂದು ತೊಂದರೆ ಕೊಡಬಾರ್ದು. ಮೊದಲೇ ಕಡಿಮೆ ಜನ ಟ್ಯಾಕ್ಸ್ ಕೊಡ್ತಾರೆ. ಅಂಥವ್ರಿಗೂ ನೀವು ಟ್ರಬಲ್ ಕೊಟ್ಟುಬಿಟ್ರೆ ಎನಿವೆ. ಹರಿಗ ಇದ್ರಲ್ಲ ಇಲ್ಲ. ಎಸ್ ಹರಿಗ ಬನ್ನಿ. ಹಾ 36.1. You are appearing in that. Here you also. ಏನು ಅದಂಗ ಟೈಮ್ ಕೊಡಲ್ಲ. ಏನ್ ಹೇಳಿದ್ದಾರೆ? 7th of September 2024, what honorable president of this country has said, the court should stop the adjournment culture. ನಮ್ಗೆ ಅದು ವಾರ್ನಿಂಗ್, ಅದು ನಾವು ಕರೆಕ್ಟ್ ಹೇಳಿದಾರ. ಇಲ್ಲಪ್ಪ ಬೇರೆ ಹಿಂಗ ಹಾಕೋತ್ ಹೋಗ್ತದೆ ಅನ್ನೋದಕ್ಕೆ ಆ ರೀತಿ ಹೇಳ್ಯಾರ ಅವ್ರು. ಬೇರೆ ಕೋರ್ಟ್ ಅಂದ್ರೆ ಜನರನ್ನ ಕೇಳಿ ನೀವು, ಕೋರ್ಟ್ ಅಂದ್ರೆ ಮುಗೀತು ಅಂತಾರ ಅವ್ರ ಜನ, ಅದು ಆಗ ಹೋಗ್ಲಿದ್ದು ಅಂತ ಆರ್ಗ್ಯೂದ ಮೇಲೆ ನಾವು ಹಂಗ ಏನೋ ಒಂದು ಡಿಸೈಡ್ ಮಾಡ್ತೇವೆ ಅಲ್ವಾ. ನಂಬಿ ನಮ್ಮನ್ನು ಪ್ರೆಸಿಡೆಂಟ್ ವಾರೆಂಟ್ ನಲ್ಲಿ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದೇವೆ. Believe in our competence also. Presume in our competence also. Unless we confess we don't have competence. Yes. Yes, got it. ಬರ್ಲಿ ಬಿಡಿ, ಇವರು ಮಾಡಿ ಒಬ್ಬರಿದ್ರೆ ಸಾಕು. ವೇಟ್ ಮಾಡ್ಕೊಂಡು ಬರ್ತಾರೆ. ಇಲ್ಲೇ ಆಮೇಲೆ
ಇದರಲ್ಲಿ ಎಂಟ್ರಿ 97. My lord, petitioner. My lord, writ petition is in respect of a levy of service tax to the hotel industry. That writ petition prayer is at ink page 61. To declare, page 61, my lord. Declare subclause ZZZW.
Finance Act
Finance Act as beyond the legislative competency of the Parliament, and consequently to restrain respondent number 2 from imposing the service tax on the accommodation in the hotel.
105. 105 of section 65
section-
Finance Act 1964.
1964, madam. That is,
Finance 105 with effect from ಯಾವ date ಅದು?
ಅದು that is 2011 onwards. My lord, it is
ಅದೆಲ್ಲ reproduce ಮಾಡಿದ್ರೆ
ಹೌದು.
ಎಲ್ಲಿದೆ?
Page 57.
57.
Yes.
Legislative competence ಇಲ್ಲ ಅಂತನಾ?
ಇಲ್ಲ ಅಂತ.
ಯಾಕೆ?
Because it is in entry entry 97, entry 54, list 2 is a state list anta.
Constitution.
Entry.
State list ನಾಗಿದೆಯಾ? Schedule 7. Schedule 7, entry 54, taxes on the sale or purchase of goods other than newspapers subject to the provisions of entry 92 capital A of list 1. ಅದು ಎಲ್ಲಿ ಓದ್ತಾ ಇದೀರಿ?
Entry 54 of schedule 7.
List 2 da? List 1 or list 2 no?
List 2.
List 2. 54. Taxes on the sale of petroleum.
State list.
ಹೌದು. as it then ಅವಾಗ ಇದ್ದಂಗೆ ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು? As it then was.
Yes.
ಒಂದ್ ಸ್ವಲ್ಪ
ಅಲ್ಲಿ and entry 62 taxes on luxuries ಅಂತ ಇದೆ.
Entry
54 and 62
as on which date? ಅದೇನೇನೋ ಬದಲಾವಣೆ ಆಗಿದೆ.
ಹೌದು, ಇದು ಬದಲಾವಣೆ ಆಗಿದೆ.
As on which date ನೀವು ಓದ್ತಾ ಇರೋದು?
No.
As it existed when? ಆಮೇಲೆ 54 recast ಆಗಿಬಿಟ್ಟದ್ದು ನಾವು.
This is on 2010. 54. And entry 62, taxes on luxuries. Taxes on luxuries, including taxes on entertainment, amusements, and betting and gambling. Our whole contention in this, my lord, is that luxury tax is in the state list.
Luxury tax is correct.
So on that, this service tax cannot be imposed, levied anta.
Service tax is not luxury tax.
No, this there is a reference.
Service tax ಬೇರೆ, luxury tax ಬೇರೆ. Tax component ಬೇರೆ ಬೇರೆ ಇದಾವೆ ಅವು. ಈ entertainment tax ಇರ್ತದೆ.
ಅಲ್ಲ, ಕರ್ನಾಟಕ tax on luxuries ಅಂತ ಇದೆ.
Correct. But ಇಲ್ಲಿ ಹಾಕ್ತಾ ಇರೋದು service tax.
It's a service tax on the rental of accommodation in a hotel of less than 1,000 rupees. ಇಲ್ಲಿ ಏನಾಗಿದೆ 1,000 rupees ಅಂತ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. And 1,000 rupees the attracts.
Conflict ಎಲ್ಲಿದೆ ಅಂತ?
My lord, that
where is the legislative entries? Because the federal court said, I think Atiyabari na Yadav andralla. Atiyabari is now overruled. In our Supreme Court, Justice Honorable Justice M.N. Venkatachalaya's judgment in Ujgar prints, they have said, they have reiterated the entries in the schedule, in the list of schedules, are fields of legislation. They are not powers of legislation. Number one. Number two, wide interpretation has to be made of these entries. One is service tax. Another is luxury tax. A service may be luxury or may not be luxury. The state cannot impose service tax. Perhaps I do not know.
Yes, that is what.
Not in the central list. Yes. Because the difference between American Constitution and Indian Constitution is the residuary legislative powers are with center in India, whereas they are with the provinces in the states in America. All residuary power are equal.
Here,
ಇಲ್ಲಿ ನಮ್ಮ ಸೆಂಟರ್ ಕೊಟ್ಬಿಟ್ಟು
center.
ಬಾಬಾ ಸಾಹೇಬ್ರ ಹೆಂಗ್ ಮಾಡ್ಯಾರ ಅಲ್ಲಿ ವೆರಿ ದಿ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಅಂತ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಇದ್ದಾಗ ಮುಂದೆ ನಾವು ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಇದಕ್ಕೆಲ್ಲ ಹೋಗ್ತೇವೆ. ಆ ಟ್ಯಾಕ್ಸ್ ಕಾಂಪೋನೆಂಟ್ ಬೇರೆ, ಈ ಟ್ಯಾಕ್ಸ್ ಕಾಂಪೋನೆಂಟ್. ಹೌ Honorable Justice Nagartna has treated, let us see.
Yes, my lord, there is also a judgment, my lord, when the matter was listed on 25/11/2019, this matter was posted. A judgment of Kerala High Court, division bench judgment of Kerala High Court was brought to the notice of the court. Then the court, referring to that, just referred that these appeals may be posted after the disposal of the matters in Supreme Court filed by the center.
Brother, that will take, we recall that order. We can't wait endlessly.
Yes.
It's impossible. Unless Supreme Court says, for example, Section 24 of 2013 Act, no court shall touch the papers relating to. That was the injunction. If there is such an injunction, otherwise endlessly, we cannot wait that.
It's not that.
One sentence, Cabinet Council for the appellant brought to our notice a coordinate bench decision
of Kerala
to await the decision of the apex court in a matter arising from state of Kerala, from Kerala state.
Yes, my lord. Writ appeal number 1125.
Writ appeal.
Writ appeal number
Kerala decision, that is DB decision of Kerala High Court in writ appeal number 1125 of
comma 1180
25/11/80 of
comma 12/0
of
2013, man.
2013. First time. We can't endlessly keep this matter pending, awaiting the decision of the apex court. First time. Therefore, we declined the request for deferring the matter. First, all right. Preface. All right. Yes,
my lord, I'll just pass on.
We also told Learned Counsel appearing for the appellant about decision of the apex court in Section 24 judgment, famous judgment. Section 24 judgment, which is that judgment? Famous judgment, Baroda municipality versus so and so, so and so. Third, where there was an injunction restraining the courts in the country from entertaining any challenge relating to section, any question relating to Section 24 of 2013 Act. First off, obviously, Indore and Baroda, two judgments. Okay.
Yes, may I pass on that judgment?
But it held in your favor.
Yes. That refers to the Bombay High Court had taken a different view. Contrary view, which was not agreed.
Kerala did not agree with that.
Not agreed.
So now field is open to us now.
Yes.
Yes, sir.
My lord, may straight away go to page 21 of that judgment. It says, in view of the decision of the apex court in Godfrey Phillips India Limited, we have no hesitation to hold that the matter covered by subclause ZZZ W of clause one.
So it fits into entry 62 of list 2 ಅಂತ ಹೇಳ್ತಾರೆ.
Yes.
ಹಾಗಾಗಿ center has no legislative competence ಅಂತ. State alone has got legislative point.
That's the only issue in this matter. And one reference at internal, that page 24 also. The conclusion. It is beyond dispute, third line. It is beyond dispute that by virtue of the provision in Article 366 within 20(29)(a) of the Constitution, even the service part involved in the supply of food and other articles of human consumption is deemed as a sale to enable the states to impose tax on the same. The point therefore is as to whether, having characterized constitutionally the subject matter of supply of food in restaurant, including the service part of it as a sale, can the Parliament characterize the same transaction as a service for imposition and levy of tax? We are of the view that since the whole of the consideration received by restaurant owner for supply of food and other articles of the human consumption, including the service part of the transaction, is exigible to tax by the state by virtue of the constitutional definition, it is not open to the Union to characterize the same transaction as a service for imposition and levy of service tax. We are therefore unable to agree with the view taken by the Bombay High Court. In the aforesaid view of the matter, we do not find any reason to interfere with the decision of the learned single judge. Only on legislative competence. And here, my lord, this petitioner has paid the tax demanded under protest. That is about 1,29,000. That is already paid, and this tax is no longer in existence in a statute book.
No, that is
now
for a particular year.
Yes, a particular year.
We agree with the Bombay High Court. Yes.
My lord, the only thing is, I am a small fry, but the other petition.
Let him argue. Yes. Come. No time will be granted. You have seen what the Honorable President has, Her Excellency, the President has said. No adjournment culture. See the speech of 7th September 2024. We don't give. Please, sir, we will not give you. Pass over. Same order. Dismissed. Agreeing with the learned single judge. We respectfully agree with the judgment of Bombay High Court and equally respectfully disagree with that of the Kerala High Court. Kerala. Refer to Ujgar prints. Mention Sirwai. Yes. Please.
Respondent.
Lords, may I seek for tomorrow or next Monday, my lords? Tomorrow or next Monday, it's possible.
Difficulty.
No, I just want to prepare.
Sir, Monday we'll have that.
Tuesday. ಅಲ್ಲ ಟ್ಯೂಸ್ಡೇ ಕಷ್ಟ ಆಗತ್ತೆ ನಮಗೆ ಧಾರವಾಡದಲ್ಲಿ
Some other day we'll.
ಅಲ್ಲ
I'm ready. Tomorrow is okay.
Tomorrow is okay.
Tomorrow. Call tomorrow. Yes. Any issue other?
What
I can begin, my lords, but the only thing is I'm not.
What is that?
It is very simple, my lords. The assessee sells it to an exporter. The exporter sells it to somebody abroad, some customer abroad. Under the act, this is because it is the penultimate sale pursuant to fulfilling an order of export.
exemption is granted. He is required to do only two things. One, he has to produce the agreement of export between the ultimate seller and the purchaser abroad, and purchase order, agreement, whatever is there. Second, he is required to file the Form H, and he is required to show it in his returns. None of these three are there. There ends the case. If he can show 1, 2, 3 are there, I have no legs to stand on. If he is not able to show it, he has no legs to stand on.
Factually, it is incorrect.
No, not a
Kindly see my acknowledgement for filing for
Ready now?
capture. It is there.
Are you ready now?
I'll make a beginning, my lord.
Then
But
not
only
this.
thing is what I am
I have
submitting.
understood the case. I have read the paper.
Yes,
Yes,
it
next
is
tomorrow.
already there. Their documents are there. Tomorrow.
Tomorrow.
Not in the case, my lords, is the order of the Special Court Land Grabbing Act, which has passed the order at my lords would get it. Connection EM. Page number 30. It's not in dispute that the case which was pending before the learned Chief Metropolitan Magistrate Bangalore has been transferred straight away based on the notification of the Honorable City Civil and Sessions Judge, which is being attacked, which is contrary to the law laid down by this Honorable Court.
This Arvind Kumar judgmental cover agatta.
They say there should be a consideration. At that consideration, when it is absent, the special court has to consider whether it was transferred on the proper consideration. And the special court was given the jurisdiction to hear such cases which are transferred on the basis of the jurisdiction. Therefore, it was properly heard on the basis of the jurisdiction. My lord would get it at page number 31, previous page. Order dated 6/9/2021. ನ್ಯಾಯಾಲಯದ ವ್ಯಾಪ್ತಿಯ ಬಗ್ಗೆ ಸುನಾವಣೆಗಾಗಿ ದಿನಾಂಕ 29/9/21 ಪ್ರಕರಣವನ್ನು ಕರೆಯಲಾಗುವುದು. Then it was heard, and though the submissions were made, it was not considered by the
afternoon. Come in the afternoon.
That's covered by.
Let us.
Any chance tomorrow, Mila?
No. Afternoon. Let's say Shatre.
Sir, I am ready. Your lordship is it has been agent from time to time. Several times I am ready. I will argue it afternoon. Your lordship is even ready now because your lordship got in. But
my lord, I have
ready. Every time they are seeking a time. The poor daily wages employed. 30 years I worked it. They are every time.
ನಾಲ್ಕು ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆಯೋದಿದೆ ಬರ್ಕೊಂಡು ಬಂದ್ಬಿಡ್ತೀವಿ ಮಧ್ಯಾಹ್ನ ಮುಗಿಸ್ತದೆ ಟೈಮಿಗೆ ಕೊಡೋದು.
ಇದಕ್ಕೋಸ್ಕರ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಟ್ರೈಬ್ಯುನಲ್ 3 o'clock ಒಂದು ಮ್ಯಾಟ್ರ್ ಇಟ್ಟಿದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ. ಸರ್ ಎಷ್ಟೋ ಕೇಸ್ಗಳು ಲೇಬರ್ ಕೇಸ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀನಿ, ಇದ್ರಲ್ಲಿ ನಮ್ಗೆ ಕಷ್ಟ ಏನಿಲ್ಲ. ಟೈಮ್ ಇವತ್ತೊಂದು 3 ಗಂಟೆಗೆ ಅದು ಇನ್ಕ ಸರ್ ಗೊತ್ತು ಸರ್. ಸ್ವಲ್ಪ TCR ಸ್ವಲ್ಪ ಕೊಡಿ ಸರ್, ನೋಡ್ತೀನಿ. ಆಯ್ತು ಆಯ್ತು, ನೋ ಪ್ರಾಬ್ಲಮ್. ಆಯ್ತು, ಇಲ್ಲ ಆರ್ಡರ್ ಅವಾರ್ಡ್ಗೆ ಹೋಗಿದೆ ಅದು ಇವಾಗ. ಅವಾರ್ಡ್ ಹೋಗಿದೆ ಅದು. ಆಯ್ತು, ನೋ ಪ್ರಾಬ್ಲಮ್.
ಅದನ್ನ ಹೋಗಿದ್ರಲ್ಲ ಯಾವಾಗ ಮಾಡ್ತೀನಿ ನಮ್ಗೆ ತೊಂದರೆ ಇಲ್ಲ.
ಆಯ್ತು.
My lord, one accommodation, I'll produce it by
Call
next.
this matter. On the other date, after 2 weeks. See, now we have written this. We have told our court officer to show every order to us.
I apologize, my lord.
Speak to enable learned counsel for the petitioner to come and argue. ಬರುವುದಿಲ್ಲ ಕೋರ್ಟ್ಗೆ ಬರಲ್ಲ.
I apologize. Previous occasion, I couldn't be there. Prior to that, all the hearing I have been present, my lord.
Our direction was to produce the copy of gift deed.
Yes, my lord. They are yet to
Call
get
after
it.
2 weeks at the request of counsel for the petitioner finally
Please, my.
to comply with the order dated 4/11/2024.
Please.
I'm extremely sorry to
Yes.
interrupt. And that's the online, I couldn't mention online because the mic and camera were off earlier. May I just humbly mention one matter, my lords? It was supposed to be in the list for today. Your lordships had directed it on 15th of January. Writ appeal number 992. My colleague is there. She'll just hand over the memo. My lords, it's not there in the list. May I just request for day after tomorrow, my lords?
It must be posted for 12th, my lord. It was a date given matter. It was supposed to be listed today. So it was not listed. It may be posted on the 12th. Same number. Yes. Yes, my lord. Division bench.
All right, actually, postmark.
I'm so grateful.
Obliged.
So grateful.
Speak to my lord.
Yes, Radhanam.
The annexure A may be kindly perused.
Padi.
Page number 30. The Chief Metropolitan Magistrate Court, Bangalore has transferred the pending CC to this court based on the City Civil Court notification dated so and so. The entire, including the order sheet, charge sheet has been received. Now, this is the only order which is forthcoming from the records. My lords may kindly appreciate it's a covered by decision of this honorable court, wherein this honorable court was pleased to hold.
My lordship, that covered by is in regarding the challenging of the act. That has been upheld
Fully
by the
transferred.
division bench.
No, which matter should be transferred ಅಂತನೂ ಇದೆ.
Transfer.
ಅರವಿಂದ್ ಕುಮಾರ್ ಸಾಹೇಬ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಅನ್ನು ಕೊಡಿ. ಅದು ಇದೆ, ಎರಡೂ ಇದೆ. ವ್ಯಾಲಿಡಿಟಿ ಪ್ಲಸ್ jurisdiction.
The relevant portion I'm handing over, my lords, this is bulky one, page 590 of the order.
ರಿಪೋರ್ಟ್ ಆಗಿದೆಯಲ್ಲ ಅದು.
Report ಆಗಿದೆ. Report ಆಗಿದೆ.
ILR ಏನು ಅಂತ ಏನು paragraph
Paragraph 9 regarding transfer of cases.
page number
Page 590.
590. Transfer of case.
Yes, my lords.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ.
There, I take my law to
Copy
the next page.
Regarding transfer of cases.
Yes, my
heading.
lords. Yes, my lords.
Transfer ಇದೆ.
Then,
Come
my
to
lordship,
page
but
590.
This issue is regarding 192A of Land Revenue Act. Kindly see the FIR, my lordship.
Let me, my,
ಅಲ್ಲ 590 ಬನ್ನಿ.
it, next page, my lord may kindly come to next page. Law, after the third line, it came to be held in WP number so and so, disposed of on 26/9/2019 as under. A relevant paragraph is in the next page. For an action to be initiated under the
Page
act,
number ಹೇಳ್ಬೇಕು.
para number 26.
592-26.
How so? For an action to be initiated under the act, there has to be a positive action by the authorities concerned. In that, there is to be positive proceedings which are to be initiated against the land grabber for an action of land grabbing. It is only those proceedings which are pending before any authority or court which shall be required to be transferred to the special court. Then, my lords, I take the relevant portion is there are three criteria that is listed. The third criteria at page number 593.
3.
House.
Out of 1, 2, 3,
How?
third is attracted.
Yes,
ಅಂತನಾ?
ma'am. Yes, ma'am.
ಓದಿ.
ಮೂರು ಓದ್ಬಿಡ್ತೀನಿ sir.
ಹಾ.
Number 1. The court of authority before whom such proceeding is pending is required to record a reasoned finding as to whether the act is attracted to that fact of the situation after having arrived at a conclusion that land is a government land. Arrive at the conclusion that land act applies to the land in terms of section 1(2) of the act. that is a land defined under section 2D. Plaintiff has committed an act grabbing the land in terms of section 2B without lawful entitlement with a view to illegally take possession of such land, to enter into, create or illegal tenancies or lease and licenses agreements, construct unauthorized structures thereon for sale or hire, or give such any land for any person or rent or lease or license basis for the such construction. Now, page 30 may be kindly perused. Then the section, the para 30 at page 594, they say the constitution of special courts, the honorable court discusses on that issue.
If any action of land grabbing has
Has
not been
committed,
committed,
plaintiff then cannot be termed as a land grabber. There is no unlawful act committed. Hence, terms of section 7.1, the special court would not have that jurisdiction in the matter. Section 7.1 of the cant is reproduced as under. Then, my lords, I take my lords to para 34, 597.
31 Bani.
31. In such circumstances, any such pending action cannot be transferred to a special court in terms of section 20. The court before whom the matter is pending would have to proceed with the same in the ordinary course. Under special circumstances, in WP number so
Under similar circumstances.
How?
Special.
Sorry. Similar circumstances. We have held. Now here, my lord may kindly appreciate, they refer to the facts of the case in that case. Then relevant para is para 33 at next page, 596.
The above being the position.
The action of the principal civil judge and JMFC Mandya said to have acting under the proceedings of the principal district judge at Mandya, transferring records in so-and-so to special courts for disposal, referring to a notification issued by the government of Karnataka dated so-and-so, and circular of this court dated so-and-so in a perfunctory manner is impermissible. The circular of this court dated does not withdraw or transfer the cases to the special court. The said circle only informs the jurisdictional district and sessions judge of the constitution of the court and instructs such judges to withdraw and transfer the cases falling under the act. In my case also, they only refer to the notification of the honorable principal district and sessions judge.
Next story. It is therefore
incumbent upon the presiding officers where a particular case is pending before such courts to arrive at a conclusion that particular case would satisfy the requirement of section 20 of the act. Only after recording such satisfaction, the presiding officer of such court would be empowered to transfer the matter to the special court. In the present case, there is no objective satisfaction of the requirement of section 20 of the act recorded by the principal civil judge and JMFC Mandya, and trial court has proceeded with the transfer of the case as if the circular dated 22/3/2017 withdraws all the cases and transfers the same to the special court constituted under the act, when in such fact does not. In the circular category, it is makes clear that only such cases falling under the act are to be transferred. The determination thereof has to be made by judicial order by the presiding officer, and it cannot be mechanically transfer all the matters merely because there is an allegation of land grabbing of any such parties to the list. This was the finding recorded. Then the general directions are at page 115, para 115 at page 598. In the light of the law laid down in the said writ petition, we are of the considered view, whenever the matter suits which are pending before the authorities or civil courts, which has been transferred contrary to dicta laid down in the aforesaid case, would require re-examination or reconsideration by the special court. Hence, we direct the special court to examine such cases and pass appropriate orders, keeping in mind the observations made by this court in WP number so-and-so, dispose of so-and-so. The petitions are also at liberty to move the special court for appropriate orders being passed in this regard. In my case also, my lords, the magistrate straight away transfers the case.
Show that.
The page number 30. The Chief Metropolitan Magistrate Bengaluru has transferred the pending CC to this court based on the city civil court notification dated so-and-so. These are only material available.
Where is the consideration?
My lordship, that is based on the notification passed by the city civil court.
Which is
I
that
read
notification?
The para 34 of the judgment, my lordship.
34.
It is clear that the 597 page number. 597. I'll read last 4 lines, my lordship. The determination thereof,
595 ಅಲ್ಲ
597 ಅಲ್ಲಿ 34 last 4 lines.
34 last 4. The determination thereof has to be made by a judicial order by the presiding officer. It cannot mechanically transfer all matters merely because there is an allegation of land grabbing by any of the parties to the list. Ida?
That's what, my lordship, where there is a order by the city civil court of the judicial, the notification which is issued by the so and so, my lordship.
ಎಲ್ಲಿದೆ ಫೈಂಡಿಂಗ್ ಎಲ್ಲಿದೆ ಅದು ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ
That
ಹಂಗೆ
order-
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡೋದು
Like, that order has not been produced. The
It's
RBI
there.
does-
I have downloaded it. This is the order passed.
ಕೊಡಿ.
Pin ಮಾಡು. Pin ಮಾಡು. ಬರೀ ಆರ್ಡರ್ ಶೀಟ್ ಮಾತ್ರ ರೆಕಾರ್ಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ. There is no separate order passed.
No separate order passed.
There is no separate.
Where is that order? 31/5/2017.
That is a notification, my lordship.
So you cannot, you have to record a finding
My lordship, how-
in terms of this judgment. You have to hold proceedings. You should hear them.
This judgment is of 2020, but the notification of is year of 2017.
Therefore, that
It's
is
prior to
interpreted.
the judgment, my lordship, notification,
Correct.
prior to the judgment.
Therefore, in terms of this judgment, you have to
Judgment
hold
is
the proceedings.
That's what.
It does
my
not
lordship,
save.
but Retrospect, lordship, because the judgment is in the year of the 2021.
Judgment interpreting the provisions of law are always retrospective. Unless the judgment says these are prospective, which High Court cannot say because of IC Golaknath. Whether it should be prospective or retrospective, only Supreme Court can say that. No other court can say. If judgment interprets law or a judgment interprets a judgment, that is always with retrospective effect.
Lordship, I'll go through with this judgment again, my lordship. The question is, the 304A, they can, CMM court can deal with that, my lordship. There is 192C section also, which is referred in the FIR, my lordship.
No, that's not it. Where is the finding by the court which transferred it? ಅದು ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು ಅಂತ ಇವರು ಬರೆಯೋದು ಡಿವಿಷನ್ ಬೆಂಚ್. ಟು ದ್ಯಾಟ್ ಇಫೆಕ್ಟ್ ಆದ್ರೆ ಮಾತ್ರ ಆಗತ್ತೆ, ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಆಗಲ್ಲ.
Otherwise, it can be remit back before the same court to consideration.
ರಿಮೈಂಡ್ ಮಾಡ್ಕೋತೀರಾ?
ಸ್ವಾಮಿ
ರಿಮೈಂಡ್ ಮಾಡ್ಕೊಂಡು
ಅಲ್ಲ, this is already
ಮಾಡ್ಬಾರ್ದು
considered.
ಅನ್ಲಿಕ್ಕೆ ಏನಿದೆ ಪ್ರಾವಿಷನ್ ನಿಮ್ಗೆ?
Order regarding jurisdiction of this court has been passed by the special court. That has been challenged before this honorable court. He holds.
ನಾ ದಟ್ ಅದ್ ಬಿಡಿ, ಅದನ್ನ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ಮಾಡೋಂತ ಮತ್ ಬೇರೆ ಆ ಕೋರ್ಟ್ ಹೋಲ್ಡ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅದು.
Then it has go back to the magistrate court.
ಹೌದು, ಅವ್ರು ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು.
ಹೌದು.
What Chandani says appears to be sensible, because that court has to take the decision in terms of division
Yes, madam.
bench
Or
order.
that proceedings before the special court may be kindly quashed and
That's
parties may be relegated to the.
My lordship, if it's been passed, then entire this will goes, my lordship.
No, enter not. That order which transfers the case to him, and that court says we have jurisdiction, that will go.
No, they tell they may not have jurisdiction because 192C of land revenue is they cannot, magistrate cannot go with the 192C of Karnataka land revenue, my lordship. That's what Karnataka land revenue says.
192.
See,
Now what it says?
any other laws. Here only not 304A ಒಂದೇ ಇಲ್ಲ section, ಅದ್ರ ಜೊತೆ ಬೇರೆ sections ಇದೆ.
Whatever it is that he has to say.
But that judge has to say. The transferring court has to say. Even that may be a ground. Petition allowed in terms of the division bench decision of this court in WP 47747 of 2017. ILR ನೋಡ್ಕೊಳ್ಳಿ ಅದು ಯಾವುದು? ILR ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. ILR ಹೇಳ್ಬೇಕು. ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಅದು.
ಎಲ್ಲರಲ್ಲಿ
ಇದೆ. ILR ರಿಪೋರ್ಟ್ ಆಗಿದೆ. So full stop. Refer to various paragraphs. Full stop. The order of the special court is quashed. Semicolon. The order of the court which transferred the proceedings to the special court is also quashed. First stop. As a consequence, matter is remitted to the court of
Chief Judicial. Chief Metropolitan Magistrate Court, Bangalore.
CMM order.
Chief Court is.
Chief Metropolitan Magistrate Court for consideration of fresh in terms of the judgment, in terms of the said decision, and after giving an opportunity of hearing to both the sides. First, note the submission of learned HCGP. Okay.
Hello.
All contentions kept open.
Hello.
ILR ಹೇಳ್ಬೇಕು. ಅದರಲ್ಲೇ ಇಡಬೇಕು ಈ ಆರ್ಡರ್. 44 ಬಡಿ.
Limited issue, my lord. Limited, small issue.
My
lord, section 148 deals with issuance of notice, my lord, for assessing income which has escaped assessment.
Okay.
Section 149 lays down that no notice under section 148 shall be issued beyond 3 years from the end of the assessment year,
And
unless
without
the
leave of
assessing
the-
authority has, my lord, information regard to the books of accounts, documents, and other materials, my lord, which suggests that income which has escaped is above 50 lakhs or above.
So that is second condition.
So no, if the time limit is beyond 3 years from the end of the assessment year, no notice can be issued unless the assessing authority has got some information that income assessed
More than 50
escaped
lakhs
assessment
ಇದ್ರೆ
more than 50
limitation
lakhs.
ಇಲ್ಲ.
Here in this case, my lord, what has happened is some information came to be received that certain sale transactions have happened amounting to rupees 55 lakhs. Then, my lord, under 148A B, an opportunity is given to the assessee, putting him notice. Why notice under 148 cannot be issued? And, my lord, he will be
148 and reopening of the assessment.
assessment.
ಅನ್ನೋದು.
148A, my lord, earlier 148 notice could be issued. Then, my lord, in GK and Drive Shaft, the Honorable Apex Court held that when a writ petition was filed, Apex Court held if before coming to the court, you seek for reasons recorded in writing, and the officer is bound to
Give
consider
reasons.
your objections, then pass a speaking order, which was not there in the section itself.
It's because of the judgment. it-
Judgment. Then subsequently, my lord, 148 capital A was brought in, which, my lord, would give an opportunity to the assessee to.
So 148 capital A enacted the judgment in
Yes,
a way.
in a way.
Okay.
Now, my lord, facts of the cases, the information came to be sent to the assessing authority that a sale transaction had taken place amounting to 55 crores. My lord,
55
a reply came to be filed,
55 lakhs.
55 lakhs. Then, my lord, an order, after receiving the objections of the assessee, the officer has to pass an order under 145 capital A D.
Giving reasons.
Now, passing an order
Order
on the
it.
objections
Okay.
before issuance of 148 notice. That order came to be passed. Essentially, the contention of the assessee was, yes, there is a transaction amounting to 55 lakhs, but my cost of investment in that is 15 lakhs.
Minus ಮಾಡಬೇಕು.
Minus 50 lakhs.
55 ಆಗೋದು 50 ಆಗೋದೇ ಇಲ್ಲ.
ಆಗೋದಿಲ್ಲ. The department's contention is, my lord, that gross amount has to be taken.
ಹೌದು.
ಅಷ್ಟೇ. Now, my
Cost of
lord,
acquisition ನೋಡಲ್ವಾ?
ಕೊಡ್ಬೇಕು.
ಏನಿದೆ ಇದರಲ್ಲಿ? ಮಕ್ಕಳಿಗೆ.
My lord, page number 32. I am told, my lord, the judgment of the learned single judge was referred to by High Court of
Of the Madhya Pradesh High Court.
High Court of Madhya Pradesh.
It was followed by the division bench there. Review petition also dismissed and SLP also dismissed.
So matter has attained finality.
Review petition.
My lord, page number 31 and 32, Inc.
ಇದರ ಕವರ್ಡ್ ಬೈ ಇದಾಗತ್ತೆ.
ಹೌದಾಗತ್ತೆ. I am told, my lord, SLP also is dismissed.
ಬರ್ಕೊಳ್ಳಿ. ಕೂತ್ಕೊಳ್ಳಿ. This intra-court appeal seeks to call in question a learned single judge's order dated 24 May 2023, whereby respondent assessees poster payers WP number 7647 of 2023 TIT having been favored, relief has been accorded to him as under para 21 anna reproduce ಮಾಡಿ. Next. Learned senior panel counsel appearing for the revenue vehemently argues that the impugned order being contrary to the scheme of section 149 of the IT Act 1961, comma, once the amount of rupees 50 lakh is ascertained as escaped assessment, escaped income for assessment, comma, the interference of the writ court was uncalled for. First up. Learned counsel appearing for the assessee per contra submits that merely because the concerned conveyance mentioned 55 lakh rupees, comma, that itself cannot be taken as the figure escaping assessment.
Income escaping assessment.
Income escaping assessment, in as much as the cost of acquisition has to be minused from it. And if that is done, it falls below the ceiling limit of rupees 50 lakh.
Section 48 lays down this concept.
This aspect of the matter, comma, learned counsel appearing for the assessee submits, comma, was considered by a division bench of Madhya Pradesh High Court sitting at Jabalpur in Nitin Nema versus Office of Principal Chief Commissioner of Income Tax, WP 8311 of 2023, and relief has been accorded to the assessee of the kind.
My lord, after taking note
This
after taking note of the impugned order of the learned single judge. Lord, Madhya Pradesh High Court,
after referring to the order impugned in this writ appeal, full stop. He also tells us that challenge to the Jabalpur bench order has attained finality at the hands of the apex court in SLP number
38708 of 24.
38708 of 2024. And therefore, the order of the learned single judge has secured imprimatur of the apex court. Full stop. So contending, he seeks dismissal of the writ petition. Writ appeal. Next, having heard the learned counsel appearing for the parties and having perused the appeal papers, we are broadly in agreement with the views of the learned single judge, inter-alia, to the effect that while assessing the quantum of escaped income in matters like this, comma, the amount mentioned in the registered conveyance cannot be straightway taken without deducting the cost of acquisition therefrom. First, this apart, as rightly submitted by learned counsel appearing for the assessee, the Jabalpur bench of Madhya Pradesh High Court in the case Supra followed the impugned order of the learned single judge of this court, and later the challenge by the revenue before the apex court of the country has been repelled. Full stop. Next part. In the above circumstances, there is no merit in the appeal, and therefore, accordingly, it is dismissed. Costs having been made easy. Third.
I may kindly be permitted to place a few documents on record, few documents pertaining to the dispute pending for regularization.
Yes.
Before seizing.
I am not connected with the.
It's
I
not-
am placing the records.
He had given a copy.
I am placing the records.
I'll answer it.
But he is
Very
also respectable. See, ನೀವು ಅವ್ರಿಗೆ ಜೋರ್ ಮಾಡಿ ಪಾಪ ಅವ್ರು ಏನ್ ಮಾಡಿ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ನೀವು ಮಾಡ್ತೀರಾ
Last time,
ಆನ್ರೇಬಲಿ ಮಾಡಿ.
I am not a party to the regularization before seizing. ಅಧಿಕಾರ
ನಾನು ಅದು ಯೂನಿಯನ್ ಅವ್ರು ಹಾಕಿದ್ದು ನಾನ್ ಹಾಕಿದ್ದಲ್ಲ. 211 ಮೆಂಬರ್ಸ್ ಮೆನ್ಷನ್ ಮಾಡಿ ಯೂನಿಯನ್ ಅವ್ರು ಹಾಕಿದ್ದು, ನಾನು ಹಾಕಿದ್ದಲ್ಲ ಅದು. My learned friend, then your lordship asked last time asked a question whether you are a coolie. You are receiving only coolie. But that is your lordship may have see the documents produced.
ಸರಿ ಇನ್ನೊಂದ್ಸರಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಎಷ್ಟು ದಿವಸ ಆದ್ಮೇಲೆ ನೆನ್ಕೊಳ್ಳಿ ಕೇಸ್ ಮುಗಿದಿರ್ತದೆ.
But the petitioner was appointed as a messenger cum sweeper, on 4/6/1993.
ಒಂದೇ ನಿಮಿಷ. Appointment order.
That he was appointed on messenger cum sweeper on 4/6/1993.
93.
4/6.
ಏನಂತ?
The messenger cum sweeper.
ಅದೆಲ್ಲಿದೆ?
ಅದು ನಮ್ಮದು ಕಾಪಿ ಕೊಡ್ಲಿಲ್ಲ, ನಾವು ಅಟೆಂಡೆನ್ಸ್ ರಿಜಿಸ್ಟರ್ ಇದೆಲ್ಲ ಅವ್ರ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕೊಡ್ಲಿಲ್ಲ. ಐ ಹ್ಯಾವ್ ಸ್ಟೇಟೆಡ್ ವೇರ್ ಐ ಹ್ಯಾವ್ ವರ್ಕ್ಡ್ ಆಲ್ಸೋ.
You have no appointment order as such.
such ಕೊಡ್ಲಿಲ್ಲ. But that registry is there, we have signed it.
ಎಲ್ಲಿದೆ ರಿಜಿಸ್ಟ್ರಿ ಇದು?
I think that is the records have come. Exactly, that is not been disputed at all, my lord, because I have adduced an evidence. They have not produced any document before the tribunal. I have adduced a document, I have produced the document. They have not produced any paper.
ಕೋರ್ಟಿಗೆ ನಮ್ ಕನ್ವಿನ್ಸ್ ಮಾಡ್ತೀರಾ ಇಲ್ಲ?
ಅದು ಮಾಡ್ತೇವೆ, ನೀವು ಹೇಳಿದಾಗ ಕೇಳ್ತೇವೆ.
ಮತ್ತೆ ನಾವು ಹೇಳಿದ್ ಕೇಳ್ಬೇಕು, ನಾವು ಕೇಳ್ತೇವೆ, ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡ್ಬೇಕು ನೀವು. ಸೊ ಯು ಡೋಂಟ್ ಹ್ಯಾವ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್.
No, my lord.
ಕೊಡಿ, ಅದು ಫೈಲ್ ಕೊಡಿ. ಇದರಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿ ನಿಮ್ಮನ್ನ ಈ ರೀತಿ ಅಪಾಯಿಂಟ್ ಮಾಡ್ರಿ ಅನ್ನೋದು ಡಾಕ್ಯುಮೆಂಟ್ ತೋರಿಸಿ.
ಅದು the message ಅದರಲ್ಲಿ if your lordship kindly see at page 102 209 ನಲ್ಲಿ ಅದರದ್ದೆಲ್ಲ ನಮ್ದು ಮೆಸೆಂಜರ್ ಅಂತೇಳಿ ಹೇಳಿ ಡ್ಯೂಟಿ ಮಾಡಿದ್ನೆಲ್ಲ ದಿ ಮೆಸೆಂಜರ್ ಕಮ್ ಸ್ವೀಪರ್ ಅಂತೇಳಿ ಅದರಲ್ಲಿ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ ಮೆಸೆಂಜರ್, ಅದ್ರ ಕೆಳಗೆ ದಿ ಪಿಟಿಷನರ್ ನೇಮ್ R.V. ಮೋಹನ್ ರೆಡ್ಡಿ ಅಂತೇಳಿ ಹೇಳಿ ಪೇಜ್ 106 ನಲ್ಲಿ ಅದು 4th ಕಾಲಮ್ ಅಂಡ್ 8th ಕಾಲಮ್ ನಲ್ಲಿ ಇದ್ದಾಗಿದೆ. ಪೇಜ್ 209 ನಲ್ಲಿ.
ಪೇಜ್ 209?
ಹಾ, ಪ್ಲೀಸ್ ಮಿನಿಟ್ಸ್. ಅಲ್ಲ, ಅದು ಅದು 210 I think 210 to 290 ಎಲ್ಲ ಪೇಜ್ 210 ಅದರಲ್ಲಿ ಕಾಲಮ್ 4ರಲ್ಲಿ ಮತ್ತೆ 8ರಲ್ಲಿ RV ಮೋಹನ್ ರೆಡ್ಡಿ ಅಂತ ಹೇಳಿದೆ ಮೆಸೆಂಜರ್. ನಾವು ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಅವ್ರು ಹೇಳಿದ ಕಳಿಸಿದ್ದನ್ನ ಡೆಲಿವರಿ ಮಾಡಿ ಸೈನ್ ಮಾಡಿಸ್ಕೊಂಡು ಬಂದಿದ್ದೇವೆ. ಅಲ್ಲಿ ಮೇಲೆ ಕಾಲಮ್ನಲ್ಲಿ ಮೆಸೆಂಜರ್ ಅಂತ ಹೇಳಿ ಅದು RV ದಿ ಮೋಹನ್ ರೆಡ್ಡಿ ಅಂತ ಹೇಳಿ ಪೇಜ್ 210.
ಮೋಹನ ರೆಡ್ಡಿ ಇದೆ.
ಅದೇ ಮೋಹನ್ ರೆಡ್ಡಿನೇ
ನೇಮ್ ಆಫ್ ಮೆಸೆಂಜರ್ ಅಂತ.
ಮೆಸೆಂಜರ್, ಹೌದು. ಇವರೇ ಹೋಗಿ ಎಲ್ಲ ಡೆಲಿವರಿ ಮಾಡಿ ಬಂದದ್ದು ಈ ಆಫೀಸಿಂದ ಬೇರೆ ಕಡೆಗೆ. ಅದು ಈಗ ಅಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಮ್ಮ ಹತ್ರ ಕೊಟ್ಟು ಬನ್ನಿ ಅಂತ ಹೇಳಿ ಅದು 2 ಕಡೆನೂ 290 ಇದೆ ಪೇಜ್ ಎಲ್ಲ, 290 210 ಇಂದ ಎಲ್ಲ ಸೇಮ್ ಡೆಲಿವರಿ ಮಾಡಿದ್ದು.
ಪ್ಯೂನ್ ಅಂತ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದಾರೆ, ಎಲ್ಲಿದೆ?
ಅದರಲ್ಲಿ ಸ್ವೀಪರ್ ಅಂತ ಹೇಳಿದೆ. ದಿ ಮೆಸೆಂಜರ್ ಅದ್ರ ಮೇಲೆ ದಿ ಮೆಸೆಂಜರ್ ಅಂತ ಹೇಳಿ ಬರ್ದಿದ್ದಾರೆ.
ಅಲ್ಲ, ಮೆಸೆಂಜರ್ ನೋಡಿದೆ ನಾವು, print ಇದೆ ಅದರಲ್ಲಿ.
ಮೆಸೆಂಜರ್ ಅಂಡ್ ಮೆಸೆಂಜರ್ ಅಂತ ಹೇಳಿ ಬರ್ದಿದ್ದಾರೆ ಅದರಲ್ಲಿ. ಮೆಸೆಂಜರ್ ನಾವು ಕೊಟ್ಟು ಬಂದಿದ್ದೆ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ. Now I am a casual worker. I think that is also I produce a document now. Now my name has been also included in the provident fund, that I will place it.
ಪ್ರಾವಿಡೆಂಟ್ ಫಂಡಿಗೆ ಇದು ಮಾಡಿದ್ರಾ? ಅದನ್ನ ಒಪ್ತೀರಾ?
ಪ್ರಾವಿಡೆಂಟ್ ಫಂಡ್ ಇದೆ. ಮೇ ಮೇಕ್ ಒನ್ ಸ್ಮಾಲ್ ಬಿಕಾಸ್
ಎಸ್, ಇದು
ಪ್ರಾವಿಡೆಂಟ್ ಫಂಡ್ ಇದೆ ಸ್ವಾಮಿ.
ಆಮೇಲೆ ಹೇಳಿ.
ಈ ಪ್ರಾವಿಡೆಂಟ್ ಫಂಡ್ ಇದೆ. ನಾನು ಒಂದು ಸ್ಮಾಲ್ ಇದು ಫ್ಯಾಕ್ಚುಯಲ್ ಎರರ್ ಇದು ಮಾಡಲಿಲ್ಲ.
ಅದನ್ನ ಎಸ್ ನೋ ಹೇಳಿ ಆಮೇಲೆ
ಪರ್ಮಿಟ್ ಮಾಡಿದೆ ಒಂದು 2 minutes. ಇದು ದಿಸ್ ಈಸ್ 2A ಅಪ್ಲಿಕೇಶನ್ filed by the petitioner before CJIT alleging refusal of work. Now, my lord, I request only your last.
ನಾನು ಯಾಕಂದ್ರೆ ಅವರು ಒಂದೊಂದೇ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ತಾರೆ. ಮೊನ್ನೆ ಹೇಳಿದ್ದಾರೆ ಕೂಲಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಈಗ ಕೂಲಿ ಅಂತ ಹೇಳಿ ಯಾವ್ದೋ ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಹೇಳುದು ಕಡೆ ಬಿಟ್ಬಿಟ್ಟು ನಾನು ಹೇಳಿ
ಕೊಡ್ತೀನಿ ಎಲ್ಲ ತೋರಿಸಿ.
ಅಲ್ಲ, ಇವ್ರು ಹೇಳೋದು ಕೂಲಿ ಅಂತ ಹೇಳಿ ಬ್ಯಾಂಕ್ ಎವಿಡೆನ್ಸ್ ನಲ್ಲಿ ಅವ್ರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಕ್ಯಾಶುವಲ್ ಲೇಬರ್ ಅಂತ ಹೇಳಿ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ. ಅದೇನು ಮೇಲೆ My lord, I have stated then, my lord, the petitioner has worked in the head office of Chitradurga on 21/8/1995 to the 12/8/96.
ಅಲ್ಲ, 4/6/93 ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಯ್ತು.
ಹೌದು.
ಎಲ್ಲಿವರೆಗೆ ಕೆಲಸ ಮಾಡಿದ್ರಿ?
ನಾವು ಇಲ್ಲಿ ದಿ 4 ಬೇಡ, ಇಲ್ಲಿ ಎಕ್ಸಾಕ್ಟ್ ಡೇಟ್ ದಿ 14 13
ನಿಮ್ಮ
13 I'll mention it, my lord. The 17/4/2017 13 ವರೆಗೆ ವರ್ಕ್ ಮಾಡಿದ್ರು. 17/4/2013 ತನಕ ವರ್ಕ್ ಮಾಡಿದ್ರು. Then on 17th they refused to take me in they refused to continue the work on 17/4. ನಾನು ರಿಜಿಸ್ಟರ್ ಸೈನ್ ಮಾಡಿದ್ದೇನೆ. Then they send them me out.
10 ವರ್ಷ ವರ್ಕ್ ಮಾಡಿದ್ರಾ?
10 ವರ್ಷ 93ರಿಂದ 20 ವರ್ಷ. Then ಏನಾಯ್ತು ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ರೆ, then my lord, I given a complaint to they have refused to take it. Conciliation officer ಹತ್ರ ಹೋದೆ. ಅವರು 4-5 ಸಲ ಕರೆದ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಕನ್ಸಿಲೇಷನ್
ಅದ ಫೇಲ್ಯೂರ್ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರ ಅವರು.
ಫೇಲಿಯರ್ ರಿಪೋರ್ಟ್ ಹಾಕಿ ನೀವು ಯು ಕ್ಯಾನ್ ಇನಿಷಿಯೇಟೆಡ್ ಎ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ ಮಾಡಿದ್ರು. ದೆನ್ ಏನಾಯ್ತು ಅಂತ ಹೇಳಿದ್ರೆ, ಮೀನ್ ವೈಲ್ ದಿ ಲೇಬರ್ ಯೂನಿಯನ್ have went on strike against the removal of the several person. That your lordship
ನೀವು ಇದ್ರಾ? ಅದ್ರಾಗ ನೀವು ಇದ್ರಾ?
ನಾನಲ್ಲ ಹೋಗಿದ್ವಿ. ಸೆಕ್ರೆಟರಿ ಪ್ರೆಸಿಡೆಂಟ್ ಹೋಗಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟ, ನಾನ್ ಕೊಡ್ಲಿಲ್ಲ.
ಅಲ್ಲ,
ಅದ್ರ ಮೇಲೆ ಇವ್ರು ಸ್ಟ್ರೈಕ್. I'll answer it, your lordship, correct.
ಪ್ರಶ್ನೆ ಉತ್ತರ ಕೊಡೋದು ಬೇಡ. ನಮ್ ಪ್ರಶ್ನೆ ಉತ್ತರ ಕೊಡೋದು ಬೇಡವಾ?
ಕೊಡ್ಬೇಕು ಒಂಚೂರು ನಾವು ಸ್ವಲ್ಪ ಅಲ್ಲ, ಗೊತ್ತಾಯ್ತು. ನಾನು ಹೇಳ್ತೇನೆ ತಾವು ಆನ್ಸರ್ ಮಾಡ್ತೇನೆ. ನನ್ನನ್ನ ಕೆಲಸ ತಕೊಂಡ್ರು, ನಾನು ಅದು ಆರ್ಡರ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ. ಇದರಲ್ಲಿ ಇದೆ. ಬಿಕಾಸ್ ಐ ಡೋಂಟ್ ಐ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಔಟ್ ದಿ ಎಕ್ಸಾಮ್.
ನೀವು ನಂಗೆ ಒಂದು ಅರ್ಥ ಆಗಲ್ಲ. ಈ ಇತ್ತೀಚೆಗೆ ಲಾಯರ್ಗಳು ನಾವು ಪ್ರಶ್ನೆ ಕೇಳಿದಾಗ ಅಫೆಂಡ್ ಆಗ್ತಾ ಇದೀರಿ.
ಇಲ್ಲ,
ಅಫೆಂಡ್ ಆಗ್ತೀರಿ.
ಅಲ್ಲ, ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಕೇಳಿದ್ರೆ ನನ್ನ ಹೆಲ್ಪಿಗೆ ಅಡ್ವಾಂಟೇಜ್.
ನಿಮ್ಗೆ ಅಡ್ವಾಂಟೇಜ್. ಇಲ್ಲ ತಲೆ ಹಾಕಿ
ಇಲ್ಲ
ಒಳಗೆ ಹೋಗಿ ನಾವು
ನಿಮ್ಗೆ ನಾವು ಕನ್ವಿನ್ಸ್ ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ
ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕು.
ಅಲ್ಲ ನಿಮ್ಗೆ ಕನ್ವಿನ್ಸ್ ಮಾಡಿದ್ರೆ ನಮ್ ಕೇಸ್ ಮುಗ್ದೋಯ್ತು.
ಮತ್ತೇನದು
ಈ ಪೇಜ್ ಎನೆಕ್ಸರ್ R1 at page 13 ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಅವ್ರು ಹಾಕಿದ್ರಲ್ಲಿ.
ಜಡ್ಜ್ಗಳು ಪ್ರಶ್ನೆ ಕೇಳಿದ್ರೆ ಅಫೆಂಡ್ ಆಗ.
ಇಲ್ಲ ಇಲ್ಲ
ಧೈರ್ಯದಿಂದ ಎದುರಿಸ್ಬೇಕು.
ಇಲ್ಲ ಇಲ್ಲ ನಾನು ಅದು ಕರೆಕ್ಟ್.
ಪ್ರಶ್ನೆ ಕೊಟ್ಟು ನಾವೇನೋ
ನಾವು ಅಲ್ಲ ನಿಮ್ಮಷ್ಟು ಫಾಸ್ಟ್ ನಾವು ಇಲ್ಲ, ಅದು ಮೆಮೊರಿ ಪವರ್ ನಮ್ಗೆ ಅಷ್ಟಿಲ್ಲ.
ನಮಗೂ ಅಷ್ಟೇ ನಿಮ್ಮ
ಇಲ್ಲ ಇಲ್ಲ ನಮ್ಗೆ ಗೊತ್ತು, ನೀವು ಎಲ್ಲ ಟಕ್ 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 1 by 1 ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರೊವಿಷನ್ ಹೇಳ್ತೀರಿ. ಎಲ್ಲರಿಗೂ ಆ ಮೆಮೊರಿ ಪವರ್ ಇರುವುದಿಲ್ಲ, ಸ್ಟಡಿನೂ ಮಾಡಿರುವುದಿಲ್ಲ. ಮತ್ತೆ ಕೆಲವರೆಲ್ಲ ನಮ್ ತರ ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗಿ ಅರ್ಥ ಆಗ್ತದೆ. Page 13 in the annexure R1, the
page 13
minutes. ಅವ್ರು ಹಾಕಿದ್ರಲ್ಲಿ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾಕಂದ್ರೆ ಇದು ಕೊನೆ ಕೋರ್ಟು. ನಾವೇನ್ರ ಒಂದ್ ತಪ್ಪು ಮಾಡಿದ್ವಿ ಅಂದ್ರೆ ಅವರೇ ಆಗ್ಲಿ ನೀವಾಗ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಹೋಗಕ್ಕೆ
ಇಲ್ಲ, ಹೋಗ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಅವ್ರು ಹೋಗ್ತಾರೆ ನಮ್ಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
ಅಲ್ಲ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಆದ್ರೆ ಹಂಗಾಗಿ ನಾವು ನಿಮ್ಗೆ ಜಸ್ಟಿಸ್ ಯಾರಿಗೆ ಒಬ್ರು ಡಿನೈ ಮಾಡಕ್ಕೆ 10 ಸರಿ ವಿಚಾರ ಮಾಡ್ಬೇಕು. ನಾವು ಎಲ್ಲ ತಿಳ್ಕೊಂಡು ನಾವು ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
ಅದು ಫಸ್ಟ್ ಡಿವಿಷನ್ ಇಲ್ಲ, ರಿಟ್ ಪಿಟಿಷನ್ ಇಲ್ಲ, ಪಿಟಿಷನ್ ರಿಟ್ ಪಿಟಿಷನ್ ರಿಟ್ ಅಪೀಲ್ ಎರಡು ತಾವೇ ಡಿಸೈಡ್ ಮಾಡೋದು. ಈಗ
page 13
minutes.
ಏನದು?
Memorandum of settlement under section 12(3) of the ID Act of 1947 between the management of Pragati, the Krishna Gramina Bank, and Pragati, the Krishna Gramina Bank, Naukarara Okkutada over a charter of the demands before the conciliation officer and deputy chief labor commissioner Central Bangalore on 21/11/2016.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದೀರಿ? ಏನು
ಪೇಜ್ ಮೇಲೆ ಹೆಡ್ಡಿಂಗ್
Page 13 to my statement of objection. 13
ಹೆಡ್ಡಿಂಗ್,
that is the settlement.
13
R1
To my statement of objection.
statement of
not may pass on this
memo of the written submission. Annexure R1. ಏನಿದು ಅದ್ರಲ್ಲಿ ಏನ್ ತೋರಿಸ್ಕೊಂತ ಮಾಡಿರಿ ನೀವು?
ಅದರಲ್ಲಿ ಇವರು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಮತ್ತೆ ಯೂನಿಯನ್ ಅವರು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಯಾಕಂದ್ರೆ ಇವ್ರು ಸುಮಾರು ಜನ ಕಿತ್ತಾಕಿದ್ರು, ಅದಕ್ಕೆ ದೇ ವೆಂಟ್ ಆನ್ ಸ್ಟ್ರೈಕ್. ದೆನ್ ದಿ ಮ್ಯಾಟರ್ ದೇ ಸೆಡ್ ವಿ ವಿಲ್ ವಿಡ್ರಾ ಅವರ್ there is a
management agreed to enroll the services of the following workmen earlier called as coolies to the branches offices mentioned against their names, and they are to report for their work on or before 25/11/2016.
ದೆನ್ ಅದರಲ್ಲಿ ಇವನ ಹೆಸರು ಲಾಸ್ಟ್ ಇದೆ, ಸೀರಿಯಲ್ ನಂಬರ್ 8. ಅವ್ರ ಸೆಟಲ್ಮೆಂಟ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಇದು ಮತ್ತೆ ಯೂನಿಯನ್ ಇದು. He is your lordship at serial number 8. R.B. Mohan Reddy is
You are right.
petitioner.
ಕೂಲೀಸ್ ಅಂತ ತಗೋಬೇಕು ಅನ್ಕೊಂಡು
ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ. Then my lord, your lordship may see that at page 14, para 6.
ID 6 of 2014.
ಹೌದು,
Party then agreed to continue with the following cases pending as under. ಇದೇನು ID 6 of 2014 ಏನಿದು?
ಅದೇ ಅದನ್ನ ಅವ್ರನ್ನ ನಾವು ಅಲ್ಲಿ ಹಾಕಿದ್ದೇವೆ, ಅದನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು. That against that order I am the petitioner before your lordship now.
So both they have agreed to proceed with the case ಅಂತ.
ಹೌದು
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿಕೊಂಡು ಅದು ಹಾಕೊಂಡು ಇದನ್ನು ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೋದು, ಸೆಟಲ್ಮೆಂಟು ಇರುತ್ತೆ ಅಂತ.
ಅಲ್ಲ, ಸೆಟಲ್ಮೆಂಟ್ ಏನಂತೇಳಿ ಹೇಳಿದ್ರೆ ನಮ್ಮನ್ನು ವಾಪಸ್ ತಗೊಳ್ತೇನೆ ಅಂತೇಳಿ ಹೇಳಿ ಅವರಿಬ್ರು ಡಿಸೈಡ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಹೇಳಿದ್ರು, ಯೂನಿಯನ್ ಹೇಳಿದ್ರು ಇವ್ರನ್ನ ವಾಪಸ್ ಕೆಲಸ ತಗೊಳ್ತೇವೆ ಅಂತೇಳಿ. They were directed to report on or before the November 2016. That your lordship will.
ಅದೆಲ್ಲಿದೆ?
The
25/11 on or before 25/11/2016.
16 ಒಳಗೆ ರಿಪೋರ್ಟ್ ಮಾಡ್ಬೇಕಂತೇಳಿ ಹೇಳಿ
ತೊಗೊಂಡ್ರ ಅವರು
ತಕೊಂಡ್ರು, ಅದ್ರ ಮೇಲೆ ನಾವು ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದೇವೆ, ಅವ್ರು ತಕೊಂಡ್ರು, ಅವರು ತಕೊಂಡ್ರು.
You rejoined that.
Rejoined.
Settlement ಆಯ್ತು. Settlement.
Then he was restated on 24/11/2016.
Reported for duty.
On 24 November 2016. Yes.
ಅದಾದ್ಮೇಲೆ ಏನಾಯ್ತು?
ಅದಾದ್ಮೇಲೆ I think, my lord, your lordships, then, my lord, I have my dispute pending with the ID number 6 of 2014. Lord, I have
ಅದನ್ನ ನೀವು ಫೈಟ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿದ್ರು.
ಹೌದು.
ಅದಕ್ಕದು
ಇದನ್ನ ನನ್ನ ಕೆಲಸ ತೆಗೆದಾಕಿದ್ದಕ್ಕೂ ರೆಗ್ಯುಲೈಸೇಷನಿಗೂ ಕೆಲಸ ತೆಗೆದಾಕಿದ್ರಲ್ಲ, ನನ್ನ ಸಂಬಳ ಕೊಡ್ಲಿಲ್ಲ, ವಿದೌಟ್ ನೋಟಿಸು ಕೊಡ್ಲಿಲ್ಲ. There was no retrenchment order. There was no without any justification they removed me from service. They were not allowed to from the 2013.
ಆಯ್ತು, ವಾಪಸ್ ತಗೊಂಡಾರಲ್ಲ.
ಅದು 17/4/13 ನನಗೆ ಸಂಬಳನೂ ಕೊಡ್ಲಿಲ್ಲ.
ಹಿಂದಿನ ಪೀರಿಯಡ್
3 ವರ್ಷ ನಾನು ವರ್ಕ್ ಮಾಡಿದ ಸಂಬಳನೂ.
ಬ್ಯಾಕ್ ವೇಜಸ್ ಕೊಡ್ಬೇಕು ಅಂತ ಅನ್ಕೊಂಡು ಎಲ್ಲಿದೆ ಸೆಟಲ್ಮೆಂಟ್ ನಲ್ಲಿ?
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಸೆಟಲ್ಮೆಂಟ್ ಅವ್ರದ್ದು, ನಮ್ದು ಒಬ್ಬರದ್ದೇ ಅಲ್ಲ, ಅವ್ರ ಯೂನಿಯನ್ ಅವ್ರು ಮಾಡಿದ್ದು. ನಾನು ಐ ವಾಸ್ ನಾಟ್ ಎ ಪಾರ್ಟಿ ದೇರ್.
Are you a member of the union?
The union office bearers have done it. I have not signed it.
Are you a member of the union?
Yes, member.
It binds ಅಂತ ಹೋಲ್ಡ್ ಮಾಡ್ಯಾರ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. Union
Yes
can espouse
yes
under the Trade Unions Act, read the provisions of ID Act,
yes
the cause of workmen.
yes
Settlement arrived at between the management and the union.
yes
Bind the members of the union ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು. ಬಟ್ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ, both parties said the workmen they are agreed to continue the following cases.
ಅದೊಂದು ಆಸ್ಪೆಕ್ಟ್ ಇದೆ.
ಹೌದು. But both parties.
ಅದಕ್ಕಿತ್ತು ಹೇಳಿ, ಇದು ಯಾವ್ದಕ್ಕಿತ್ತು? ಈಗ ವಾಪಸ್ ತೊಗೊಂಡ್ಬಿಟ್ರಿ ನಿಮ್ನ.
ಹೌದು.
ಕರೆಕ್ಟಾ? ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಯ್ತು.
ಹೌದು.
ನೋಡ, ನೀವು ವಿಲ್ ಕಮ್ ಬ್ಯಾಕ್ ಟು ಯು. ಇಷ್ಟೇ ನೋಡಿದ್ರೆ ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ಆದಂಗ್ ಕಾಣ್ತದೆ.
ಹೌದು.
ಕರೆಕ್ಟಾ?
ಹೌದು.
ಅದಾದ್ಮೇಲೆ ಇವರ ರೈಟ್ ಟು ಫೈಟ್ ಈಸ್ ರಿಸರ್ವ್ಡ್ ಅಂತ ನಿಮ್ ಕಂಟೆನ್ಷನ್.
ಹೌದು.
ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ಅನ್ ಪಾರ್ಟ್ ಆಫ್ ಅಗ್ರಿಮೆಂಟ್. ಅದ್ರಲ್ಲಿ ಏನಂತ ಇತ್ತು ಅಂತ ಕೇಸ್ನಲ್ಲಿ? ಆ ಕೇಸ್ನಲ್ಲಿ
ನಮ್ಮ ಇದು ಕಿತ್ತಾಕಿದ್ದು ತಪ್ಪು, ಬ್ಯಾಕ್ ವೇಜಸ್ ಕೊಡ್ಬೇಕು. ದೆನ್ ವಿ ಆರ್ ಎಂಟೈಟೆಡ್ ಟು ರೆಗ್ಯುಲೈಸೇಷನ್. ನಾವು ಅಂದ್ರೆ 93 ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದೇವೆ ಅಂತ ಹೇಳಿ
ಕ್ಲೇಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ
ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಕ್ಲೈಮ್
ಕ್ಲೇಮ್ ನೋಡ್ರಿ
ಪೇಜ್ ಎನೆಕ್ಸರಿಗೆ
ಅಲ್ಲ, ನಿಮ್ಮ ಇದ್ರಾಗ ಸೇರ್ಬೇಕಲ್ಲ, ಒರಿಜಿನಲ್ ನೋಡಿಬಿಟ್ರೆ
ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್
ನೋಡಿ. ಕ್ಲೇಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ತೋರಿಸಿ, ನಿಮ್ ಕ್ಲೇಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಏನಿದೆ ನೋಡೋಣ. That right is reserved to you ಅಂತ ನೀವು
contention. They said I am entitled to continue the ID number 6. All our contention was left open by the
ನೋಡಿ. ನಿಮ್ಮ ID ನಿಮ್ಮ ಕ್ಲೇಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ, ಕೊಡಿ. ಎಲ್ಲಿದೆ ಸರಿ ಸರಿ ಓದಿಸಿ. ಒಂದ್ಸರಿ ತೋರಿಸಿ. ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಬೇಕು.
ಹೌದು. Then they declare that the management reinstate him their services and full packages, continuity of the service and all other consequential benefits to pass in other orders that is appropriate in the fact and circumstances.
ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ಆತು, ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್ ಬೆನಿಫಿಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋ ಮಟ್ಟಿಗೆ ಉಳಿತದೆ.
First, the hold action of the second party management to refuse the employment to him with effect from 17/4/2013, which amount to termination by retirement is invalid, inoperative and illegal. A.
Correct.
B. To direct the second party management to reinstate him into service with full back wages, continuity of service and all other consequential benefits.
ಆ ಬ್ಯಾಕ್ ವೇಜಸ್ ಒಂದು ಉಳಿತದೆ ಅಂತ ನೀವು ಹೇಳೋದು.
Back wages ಮತ್ತೆ ನಮ್ಮನ್ನು ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಲಿಕ್ಕೆ
ಕ್ಲೇಮ್ ತೋರಿಸಿ.
ಅಲ್ಲ, ಅದು ಕಂಟಿನ್ಯೂಟಿ ಆಫ್ ದ ಸರ್ವಿಸ್ ಅಂತ ಕೇಳಿದ್ದೇವೆ ಸರ್.
ರೆಗ್ಯುಲರೇಷನ್ ಆಗಲ್ಲ. ನೀವು ಹಿಂದೆ ಹೆಂಗಿದ್ರೆ ಹಾಗೆ ಕಂಟಿನ್ಯೂ ಆಗ್ರಿ ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ.
ಹಾಗಾದ್ರೆ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಬೇರೆ ಹಾಕ್ಬೇಕಂತಲ್ಲ. ನೀವೇನು ಹೇಳಿದ್ರೆ ನಾವು ತಪ್ಪು ಮಾಡಿದ್ರೆ
ತಪ್ಪಲ್ಲ, ನಿಮ್ ಕ್ಲೇಮ್ ನೋಡಿ ಅಲ್ಲಿ.
ಅಲ್ಲ, ಅದು ನಮ್ಮಂದ್ರೆ ಏನ್ ಗೊತ್ತು, ಇವರು ಅದು ಕಂಟಿನ್ಯೂಟಿ ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ರೆ they said it will be a regularized ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ರೆ. Anyway, whatever your lordships, the advice is also
ಒಂದು ರೂಲಿಂಗ್ ಕೊಡಿ ನೀವು ಹೇಳುವಂತದ್ದು. ಇಲ್ಲಿ ವಾದ ಮಾಡ್ಲಿಕ್ಕೆ ನಿಂತೀರಿ.
ಇಲ್ಲ, ನಾನು ವಾದ
ಪುಷ್ಟಿ ಅಲ್ಲ, ನಿಮ್ ಡ್ಯೂಟಿ ಅದು ವಾದ ಮಾಡೋದು. ವಾದ ಪುಷ್ಟಿಗೆ ಬೇಕಾಗುವಂತ ಒಂದೇ ಒಂದು ಪೂರ್ವ ನಿರ್ಣಯವನ್ನು ಒಂದೇ ರೂಲಿಂಗ್ ಕೊಡಿ ನಮಗೆ. ಕಂಟಿನ್ಯೂಟಿ ಆಫ್ ಸರ್ವಿಸ್ ಅಂದ್ರೆ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಅನ್ನೋ.
I will not stand on technicality, but the thousands of the employees have been regularized who put a 10 years of service. I got a copy. I'll place it before your lordship. There are a number of judgments from this honorable court.
ಅಲ್ರಿ, ನೀವಿಲ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೇನ್ರಿ? ಆರ್ಡರ್
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಆಲ್ಸೋ your lordship may kindly see the subsequently they have sought the prayer ಅಲ್ಲಿ ಏನೋ ಸ್ವಲ್ಪ ಮಿಸ್ಟೇಕ್ ಇದೆ ಅಲ್ಲಿ. ನಾನು ಹೇಳೋದು annexure A ನಲ್ಲಿ I think the subsequently there are but I cannot argue what we have sought it.
ನಿಮ್ ಡ್ಯೂಟಿ ಅದು ಆರ್ಗ್ಯೂ ಮಾಡೋದು. ಆರ್ಗ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ನಮ್ಗೆ ಗೊತ್ತಾಗೋದು ಹೆಂಗೆ?
And the tribunal also said that they thought
ವಾಪಸ್ ತೊಗೊಂಡ್ರೆ ಕೆಲ್ಸಕ್ಕೆ.
He is still working, my lord.
ನಿಮ್ಮಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
He is still working. He is working. He is working, my lord.
He is working. ಮುಗಿತು. ಅದನ್ನ ರಿಪೀಟ್ ಮಾಡಿದಾಗ ಏನು ಹೆಚ್ಚು ವರ್ಕಿಂಗ್ ಆಗಲ್ಲ ಅಷ್ಟು. ನಂಬರ್ 1. ಅವನಿಗೆ ಕಿತ್ತು ಹಾಕಿದಾಗ ಅಲ್ಲಿಂದ ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ನಲ್ಲಿ, ಎಷ್ಟು ವರ್ಷ ಹೊರಗಡೆ ಇದ್ದ?
When was he removed? When was he reinstated?
How many years he was outside the employment?
We have not removed him, my lord. Our case is that, my lord, we have not removed. He was a coolie. We used to engage whenever they used to come every day. He did not come on that day. He did not come on that day. Thereafter, he continuously he did not come.
Adili stand.
We have taken up that contention, my lord. Your lordship may kindly see the award.
ಅಲ್ಲ, ಸೆಟಲ್ಮೆಂಟ್
ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನಿದೆ, they have been asked, ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ
ವಾಪಸ್ ತಗೊಂಡಿರಿ ನೀವು ಅವ್ರನ್ನ?
ವಾಪಸ್ ತಗೊಂಡಿದೀವಿ.
ಅಲ್ಲಿ ಎಲ್ಲಿದೆ? ನೀವು ಹಿಂಗ್ ನೋಡಯ್ಯ, ನೀನು ಬಿಟ್ಟು ಹೋಗಿದ್ದೀನಿ ನೀನು ಡ್ಯೂಟಿನ, ನಿನ್ನಂತ ವಾಪಸ್ ತೊಗೊಳಕ್ ಆಗಲ್ಲ ಅಂತ ಅನ್ಕೊಂಡು ನೀವು ಬರೀತಿದ್ರಿ ಅಲ್ಲಿ.
ನಾವು ತಗೊಂಡಿದ್ದೀವಿ ಸೆಟಲ್ಮೆಂಟ್, my lord. This is a 12-3 settlement signed between the union.
Correct.
12-3 settlement is binding on all the parties.
Correct.
Including even third parties also.
Correct.
We have honored the settlement. And there was a discussion with the trade union. We have empaneled them as coolies. It is clearly stipulated in the settlement.
Correct.
We have empaneled them as coolies.
ಎಷ್ಟು ಸರಿ ಎಂಪೆನಲ್ ಮಾಡಿದ್ರಿ?
My lord,
Why are you repeating so many
seven
times?
seven people.
Taken him to duty over.
6 people, my lord.
All right. 1 minute. Now, what should happen to the period when he was outside employment? That is the only question now.
That is the only question.
ಅದಕ್ಕೆ ಏನಂತ
ಅದೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು, ಅವತ್ತಿಂದ ನಾನು ಅದೇ ಹೇಳ್ತಾ ಇರೋದು. ಆಮೇಲೆ ಇನ್ನೊಂದೇನಂತ ಹೇಳಿದ್ರೆ,
ಅಲ್ಲ, ಈ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡಿ.
What happens?
What is this?
That is between 13 and 16, your lordship.
13 to 6, 3 ವರ್ಷ.
16, 16.
Purva Rasha.
13 and 16,
Ah.
see, the CJIT took the view that during the pendency of the dispute, the settlement was reached. Settlement was reached. There is no cause of action.
1 second. Come to settlement. Please come to
My
settlement.
settlement I have seen,
ನೋಡಿರಾ?
I have seen.
So you have agreed that the litigation, he will have right to fight the litigation. Settlement is comprehensive. It is both rose and thorn. You can't say that I will take only rose and not the thorn. That's not the rule of life. You have agreed that we will reinstate you, number 1. So far as your rights are concerned, ID 6 of so and so, you can fight, you can go on fighting. That is part of the settlement. That he is saying, CJIT could not have denied whatever back wages to me, that it ought to have given our case of regularization bidi. No, ಬೇರೆನೂ regularize ಮಾಡಿರಿ.
That is the only point for consideration of this honorable court, whether the denial of back wages is justified or not.
Bad.
That's it. That's it.
ಅವನು
My lord, my only submission, my lord.
Ah.
They were only coolies. They were being engaged intermittently. Coolie, it is said in the settlement itself. They were only engaged as coolies.
ಕೂಲಿ ಕರೆಕ್ಟ್ ಇದೆ, intermittently ಅಂತ ಹೇಳಿ ತೋರಿಸಿ.
ಅಲ್ಲ, coolies ಅಂತ ಹೇಳಿದೆ ಇದರಲ್ಲಿ.
Otherwise you would have said seasonal, intermittent, part-time. Management is always wiser because they engage lawyers like you. Where have you stated? ನೋಡಯ್ಯ, ನಿನ್ನನ್ನು ನಾನು ರೆಗ್ಯುಲರ್ ಆಗಿ ತಗೊಂಡಿಲ್ಲ, ನನಗೆ ಯಾವಾಗ ಬೇಕು ಅವಾಗ ತಗೊಂಡಿನಿ, ಬೇಡಾದಾಗ ಮನೆಗೆ
Set legal position.
The settlement is not between Kallappa Mallappa. Settlement is mighty industry,
Yes, sir.
banking industry, and a feeble man here.
My lord, CJIT has not granted back wages.
Other than that is why that is his complaint here.
Daily wage workers, my lord, whether they are entitled for back wages,
Tell
that
me.
is only for your lordship.
Tell the daily wager ಅಂತ ತೋರಿಸಿ. Where have you stated in the settlement?
It is stated. It is stated in the settlement.
Daily wager ಅಂತ ಹೇಳಿ
Yes.
ತೋರಿಸಿ. Page 13 ಅಲ್ಲಿ ತೋರಿಸಿ.
13, page 13. my lord.
Workman ಅಂತ ಇದೆ.
One second. My lord, page 13, at the cost of repetition, my lord, your lordship may kindly come to terms of settlement.
ನೋಡ್ರಿ, ನಮ್ ಸಿಂಪಲ್ ಪ್ರಶ್ನೆ ಕೇಳ್ತಾ ಇದೀವಿ. ನಾವು ಕೇಳ್ತಾ ಇರೋದೇನು, ಎಷ್ಟು ಹಲ್ಲುಗಳಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀವಿ. ನೀವು ಅನ್ಕೊಂಡು ನಮ್ಗೆ ಎಣ್ಸಕ್ ಹಚ್ಬೇಡಿ, ನೀವ್ ಹೇಳಿ, ನೀವು ಡೈಲಿ ವೇಜರ್ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಿ ತೋರಿಸ್ಬಿಟ್ರೆ ಆಯ್ತಪ್ಪ.
The management agreed to enroll the services of the following workmen earlier called as coolies to the branches office mentioned against their names, and they are to report to their
ದಿನಗೂಲಿ ಬೇರೆ, ಕೂಲಿ ಬೇರೆ.
coolies.
ದಿನಗೂಲಿ ನೌಕರ ಬೇರೆ. ಧಾರವಾಡ ಡೈಲಿ ವೇಜರ್ಸ್ ಕೇಸ್ನಲ್ಲಿ AR 1989 Supreme Court, of course it is overruled in subsequently is another thing. Daily wager ಅಂತ ಅನ್ಕೊಂಡು ನೀವು ಮೆನ್ಷನ್ ಮಾಡ್ಲಿದ್ರೆ presumption is he is a regular workman. Otherwise ಹೇಳ್ತಿದ್ರಿ ನೀವು.
ಇಲ್ಲಿ coolies, my lord, they are not temporary workers also, my lord.
ತೋರಿಸಿ, ಒಂದೇ ಒಂದು, ನೀವು ಇಷ್ಟೊಂದು ವರ್ಷದ ಅನುಭವ ಇದೆಯಲ್ಲ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಲೇಬರ್ ಡಿಸ್ಪ್ಯೂಟ್ ನಲ್ಲಿ, ಒಂದು ರೂಲಿಂಗ್ ಕೊಡಿ. ನಮ್ಗಿಲ್ಲಪ್ಪ, ನಾವು ಲೇಬರ್ ಫೀಲ್ಡ್ ನಿಂದ ಬರಲ್ಲ, ನಮ್ಗೆ ತಿಳಿಸಿ ನೋಡೋಣ. ತೋರಿಸಿ.
Of course, my lord, that point has not been considered by the CJIT, my lord. I leave it to your lordship.
ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ, ಲೀವ್ ಇಟ್ಟು ಅಂದ್ರೆ ಈಗ ಹಂಗ ಹೇಳ್ಬಿಟ್ರೆ ಏನ್ ಮಾಡ,
My lord.
ಏನಾದ್ರು ಒಂದು ಪ್ಯಾಟರ್ನ್ ಕೊಡ್ಬೇಕು, ರೀಸನೇಬಲ್ ಆಗಿ ಈ ರೀತಿ ಮಾಡ್ಬೋದು.
My lord, he is still working,
ಹೌದಾ? ಒಳ್ಳೇದು.
And
ಅದಕ್ಕೆ ಹೇಳಿ,
my
ಅವ್ರಿಗೆ
lord,
ಆಯ್ತಲ್ಲ.
is a regularization case is pending, my lord. Before this CJIT,
ಆಯ್ತು ಅದ್ ಅವ್ರು ಮಾಡ್ಕೊಳ್ಳಿ,
ಅದು ಮಾಡ್ಕೊಂತಾರೆ.
ಮಾಡೋಣ. ಅವ್ರು ಇನ್ನೊಂದು 5-6 ವರ್ಷ ಮಾಡ್ಲಿ, ನೋಡೋಣಂತ 8 ವರ್ಷ
ಒಂದು
ಮಾಡ್ಲಿ.
25% ತಾವೇ ಕೊಟ್ಬಿಟ್ರೆ ಸಾಕು.
ಸುಬ್ರಹ್ಮಣ್ಯಂ,
ಅದ್ ನಿಮಗೆ ಬಿಟ್ಟಿದೆ ಸ್ವಾಮಿ, ನನಗೆ
generally you are magnanimous, you are very strong on law is one thing, but you are very magnanimous also. We have seen you at the bar, though you are a strong opponent.
I
when it
leave
comes
it to your
common
lordship.
values,
Or
you stand
may I
up.
take instruction from the client on this?
First time ಕೊಡಂಗೆ
ಬೇಡ ಬಿಡಿ.
ಸಾಕಾಗಿವೆ ಟೈಮ್ ಕೊಟ್ಟು.
I'll establish it, my lord.
I will-
Their own order, I'll place it. Your lordship may kindly pay that document.
I leave it to your
page
lordship, my
15,
lord.
page 15, para 8, I lordship permit me to read. Then their own order, I'll place it where I have said I am a casual worker. Then in the evidence, the bank manager said the casual workers are called as they are also coolie also.
ನಿಮ್ಮ ಅಗೇನೆಸ್ಟ್ ಆರ್ಗ್ಯೂ ಮಾಡಬೇಡ್ರಿ, ಸ್ವಲ್ಪ ಸುಮ್ಮನಿರ್ರಿ. ನಿಮ್ಮ ಅಗೇನೆಸ್ಟ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದೀರಿ, ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ.
Oh, yes. ಆಯ್ತು.
My lord, I agree. CJIT ought to have considered that aspect. CJIT has not considered. CJIT came to the conclusion that there is no cause of action because of subsequent. It may not be correct.
It may not be correct.
May not be correct.
Not correct.
Therefore,
ಒಪ್ಕೊಂಡಾರೆ ಇಬ್ರು.
ಅಲ್ಲಲ್ಲ.
IT 6 of 2016
ಸುಮ್ನೆ
should
ನಾನು
go on
ಅದು
ಅಂತ ಅನ್ಕೊಂಡು.
ಜಾಸ್ತಿ ಆರ್ಗ್ಯೂ ಮಾಡಕ್ ಹೋಗಲ್ಲ. My lord, I don't have,
Justice
I don't have.
ಜಾಸ್ತಿ ವಾದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಜಸ್ಟಿಸ್ ಮಾಡಿಬಿಡಿ, ಸರಿಯಾಗಿ ಹೋಗ್ತದೆ ಎಲ್ಲ.
25%,
ಏನ್ ಮಾಡಿ
25% would be.
85% ಅದಕ್ಕೆ ಪಾನ್ ಬಿಡ ತಿನ್ಕೊಂಡು ಹೋಗ್ಬೇಕು ಏನೋ ನಮ್ಮ ಅಂತ ಶಾಪು ಇಲ್ಲ ಇಲ್ಲಿ.
ತಾವೆಷ್ಟು ಕೊಡ್ತೀರೋ ಕೊಡಿ ಸ್ವಾಮಿ.
ಒಂದು ರೀಸನೇಬಲ್ ಆಗ ಹೇಳಿ.
ಎಷ್ಟು?
ಆ ರೀತಿ ಎಕ್ಸ್ಟ್ರೀಮ್ ಆಗಿ ನಂಗೆ
By way of court order 50%, my lord. By way of court order, ನನಗೇನು I don't have a mandate, 50%.
ಏನ್ರಿ
Lord, I may deal, your lordship may, I have the, your lordship last time.
ಎಷ್ಟಾಗ್ತದೆ 50%?
ಕೂಲಿ ಅಂತ ಕೇಳಿದ್ರಲ್ಲ, ಅದಕ್ಕೆ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ತಂದಿದ್ದೇನೆ.
ನೀವು
The
ಸ್ವಲ್ಪ
ಅಲ್ಲ, ತಾವು ನಿಮ್ಗೆ ಹೇಳಿದ್ದಕ್ಕೆ ಅಗೇನೆಸ್ಟ್ ಅಲ್ಲ, ಅವ್ರು ಹೇಳಿದ್ದಕ್ಕೆ ನಾನು.
ಆಯ್ತು ಇರಿ ಸ್ವಲ್ಪ ಇರಿ.
ಇದು judgment of this honorable court regularizing the several people identically, they
That is
put.
not your
ಅದು
case, it is
pending
still
ಇದೆ.
pending. Is pending. Still
Pending
you-
is, he is a worker also,
have to
he is a consultant.
decide it in a time bound manner.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ
He is a consultant worker also.
ನಾವು ಅಷ್ಟೊಳಗೆ ರಿಟೈರ್ಡ್ ಆಗ್ತೇವೆ, ಇವ್ರು ಯಾರೋ ಬೇರೆ.
Eleven ಎಲ್ಲ ಅವರು ಇದ್ದಾರೆ.
ಅಲ್ಲ
ಅದು
the-
11 ಎಲ್ಲ ಇದೆ, ಅವರು ಇದ್ದಾರೆ.
ನೋಡ್ರಿ, ಎಲ್ಲರೂ ರಿಟೈರ್ ಆಗದೆ, ನಾವೇನ್ ಇಲ್ಲೇ ಕೊಡಕ್ ಬರತ್ತೇನ್ರಿ? ಎಲ್ಲರೂ
ಇದ್ರಲ್ಲಿ-
ರಿಟೈರ್ ಆಗದೆ, ನಾವು ರಿಟೈರ್ ಆಗದೆ ಅಲ್ವಾ?
your lordship may kindly see the several other cases.
ಏನು?
They have regular, this honorable court passed an order
For
to.
fighting the legal battle after retaining that right under the settlement. You want to trample the settlement?
Not.
ಮತ್ತೆ ಯಾಕೆ?
ಇಲ್ಲ, ಯಾಕಂದ್ರೆ
ಎಷ್ಟಾಗ್ತದೆ?
ಅಲ್ಲ,
ಆ 50% ಅಮೌಂಟ್ ಆದ್ರೆ ಎಷ್ಟಾಗ್ತದೆ? ಕೂಲಿ ಎಷ್ಟಾಗ್ತದೆ? 3 ವರ್ಷ, ಎಷ್ಟು ವರ್ಷ ಹೊರಗಿದ್ರು ಅವರು? ಎಷ್ಟು ಯಾವಾಗಿಂದ ಎಲ್ಲಿವರೆಗಿದ್ರು?
3 years.
17/4/2013 ನಿಂದ
ಹಾ.
21/11 3.5 ವರ್ಷ, 3 ವರ್ಷ 7 ತಿಂಗಳು ಹೊರಗಿದ್ದಾರೆ.
ಆಯ್ತು ಸರ್.
ವರ್ಷ ಎಷ್ಟು ಕೊಡ್ತೀರಿ ನೀವು ಅವರಿಗೆ? ಮಂತ್ಲಿ ಎಷ್ಟು
wages ನೋಡಿ.
ಸ್ಯಾಲ್ರಿ ಎಷ್ಟು ಕೊಡ್ತಾ ಇದ್ರಿ ಹೇಳ್ರಿ, ನೀವ್ ಎಷ್ಟು ಕೊಡ್ತಾ ಇದೀರಿ?
ಅವಾಗ ಡೈಲಿ ವೇಜಸ್ 40 rupees ಏನೋ ಕೊಡ್ತಾರೆ.
ಅದು ಬಿಡಿ, ಡೈಲಿ ವೇಜಸ್ 40 ಕೊಡಕ್ ಬರಲ್ಲ. ನೀವೇ ಆರ್ಗ್ಯೂ ಮಾಡಿರಿ ಮಿನಿಮಮ್ ವೇಜಸ್ ಆಕ್ಟ್ ನನ್ನ ಜಜ್ಮೆಂಟ್
ಅಲ್ಲ 2013 ನಲ್ಲಿ
2013 ಜಜ್ಮೆಂಟ್ ಅದು. ಆಮೇಲೆ ನನ್ ಮುಂದ್ ಬಂದದ ಅಷ್ಟೇ, ಅದ್ ಬಿಡಿ. ಮಿನಿಮಮ್ ವೇಜಸ್ ಆಕ್ಟ್ ನಲ್ಲಿ
ಮಿನಿಮಮ್ ವೇಜಸ್ ಪ್ರಕಾರ ಕೊಡೋದು ತಾವೇ ಆರ್ಡರ್ ಮಾಡಿ ಸರ್.
ಅಲ್ಲ ಹಂಗಲ್ಲ ಫುಲ್ ಕೊಡ್ಬೇಕಾಗ್ತದೆ. ಮಿನಿಮಮ್ ವೇಜಸ್ ಓನ್ಲಿ ಅದು ಲಿವಿಂಗ್ ವೇಜ್ ಆಗ್ತದೆ. ಹಂಗಾಗಿ ರ್ಯಾಪ್ ಕಾಸ್ಟ್
shall I ascertain and come back to your lordships on Friday, my lord?
ಇಲ್ಲ ಬೇಡ ಮಾಡೇ ಬಿಡೋಣ.
ಅಥವಾ 50% ಅಂತ ಹಾಕ್ಬಿಡಿ, ಕ್ಯಾಲ್ಕುಲೇಷನ್ ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು.
ಕೊಡ್ರಿ. 3 ವರ್ಷ 11 ತಿಂಗಳು, 3 ವರ್ಷ 7 ತಿಂಗಳು.
ಹೌದೌದು.
ಮತ್ತೆ ಅವ್ನು ಬದುಕಿದ್ದೇ ಹೆಚ್ಚಿಂದು. ಅವನ್ನೆಲ್ಲ ಮುಗಿಸೇ ಬಿಡೋರು ನೀವೆಲ್ಲ, ನೀವು ಕೋರ್ಟ್ ಇರ್ಲಿದ್ರೆ. ಎನಿವೆ, ಎಷ್ಟಾಗ್ತದೆ ಅಮೌಂಟ್? ಈಗ ಎಷ್ಟು ಕೊಡ್ತಾ ಇದ್ರಿ ಸ್ಯಾಲ್ರಿ?
ಇವಾಗ 1000 ಕೊಡ್ತಾ ಇದ್ವಿ. 1000 ದಿವಸಕ್ಕೆ ಕೊಡ್ತಾ ಇದ್ವಿ. ಇವಾಗ
30,000
1,130.
ಆವಾಗ
ಸ್ಯಾಟರ್ಡೆ ಸಂಡೇ ವರ್ಕಿಂಗ್ ಡೇ,
2013
ಕೊಡುದೇ ಇಲ್ಲ, ರಜಾನೂ ಕೊಡಲ್ಲ ಒಂದ್ ದಿವಸ ನಮ್ಗೆ.
2013 ಎಷ್ಟಿದೆಯೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಅದರಿಂದ ಸ್ವಲ್ಪ
ಏನಾದ್ರು ಅರ್ಧ ದಿವಸ ಬರ್ದಿದ್ರೆ ಕಟ್ ಮಾಡಿ ಬಿಡ್ತಾರೆ.
ಇವಾಗ ಲಾಸ್ಟ್ ಇಯರ್ ಇಂದ 1000 ಕೊಡ್ತಾ ಇದೆ ಅಂತೆ.
ಮಿನಿಮಮ್ ವೇಜಸ್ ಆಕ್ಟ್ ಚಂದಿನಿ, ಮಿನಿಮಮ್ ವೇಜಸ್ ಆಕ್ಟ್ ನಲ್ಲಿ 2013
ಮಿನಿಮಮ್ ವೇಜಸ್ ಆಕ್ಟ್ 2013 ನಲ್ಲಿ ಒಂದು 8,000 ಏನೋ ಬರುತ್ತೆ. 2013 ಅಷ್ಟೇ 2013.
Reptacasa
In fact, your lordships have decided the minimum wage
therefore
cases.
telling you.
About few years back, your lordship, we have only argued.
Correct.
ಆವಾಗ 11,000 ಇತ್ತು ಅವಾಗ.
11,000 ಇತ್ತು ಆ time.
11,000 ಇತ್ತು. ಅದರಿಂದ 50% ಆಫ್ ದ ಮಿನಿಮಮ್ ವೇಜಸ್ ಅಂತ ಹಾಕ್ಬಿಟ್ರೆ ನಮ್ಗೆ ಈಸಿ ಆಗತ್ತೆ. ಕ್ಯಾಲ್ಕುಲೇಷನ್ ನಾವು ಫರ್ನಿಶ್ ಮಾಡ್ತೀವಿ.
ನಿಮ್ಗೆ ಈಸಿ ಆಗ್ತದೆ, ಪಾಪ ಅವನಿಗೆ ಭಾರ.
ಅಲ್ಲ, ನಾವು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಫರ್ನಿಶ್ ಮಾಡ್ತೀವಿ. ಇಫ್ ದೇ ಹ್ಯಾವ್ ಎನಿ ಗ್ರೀವೆನ್ಸ್, ಅದು ದಟ್ ವುಡ್ ಬಿ ಬೆಟರ್ ಮೈ ಲಾರ್ಡ್. ಓನ್ಲಿ ಮೈ ರಿಕ್ವೆಸ್ಟ್. 50% ಆಫ್ ದ ಮಿನಿಮಮ್ ವೇಜ್ ಬೇಸ್ ಅಲ್ಲಿ ಕೊಡಿ ಅಂತ ಹೇಳಿ. ಇದು
ಅಲ್ಲಿ ಏನಾದ್ರು he was gainfully employed ಅನ್ಕೊಂಡು ಏನಾದ್ರು.
ಇಲ್ಲ, ಗೇನ್ಫುಲ್ ಎಂಪ್ಲಾಯ್ಡ್ ಅಂತ ನಾನು ಆ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿಲ್ಲ. ನಾನು ತಗೊಂಡಿಲ್ಲ.
ನಾವು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೇವೆ. ನಮ್ಗೆ
ನಾನು ತಗೊಂಡಿಲ್ಲ.
I will produce the document, my lord. My wife was working as a coolie. Because of that, I have. I will read out the one sentence.
That is not there. I am admitting.
ಅವರೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಮುಗಿದ ಸುಬ್ರಹ್ಮಣ್ಯನ ಹೇಳ್ತಾರೆ.
That is not there. ನಾವು 50% back.
60% ಕೊಟ್ಟು 60%.
137 per day ಇತ್ತು.
ಹಂಗೆಲ್ಲ ಕೊಡೋದಿದ್ದು 100.
ಅಲ್ಲ, ಇವಾಗ ನೋಡಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
I will only, your lordships may 1 minute may document ತೋರಿಸ್ಬೋದ? ನೀವೊಂದ್ಸಲ ನೋಡಿ, ನಾನು ಹೇಳೋದಿಲ್ಲ. ಇದು ತಾವು ನೋಡಿ ಬಿಟ್ರು ಗೊತ್ತಾಗ್ತದೆ. ನಾನೇನು ಹೇಳೋದಿಲ್ಲ. ಈಗ
ಕೊಡಿ. ಇವೆಲ್ಲ ಇವು ಹೆಚ್ಚು ಮರ್ಸಿ ಪಿಟಿಷನ್ ಟೈಪ್ ಇವು.
ಇನ್ನೊಂದು ಕಾಪಿ.
ನಮ್ಮ ಮುಂದೆ ನಾವು ಆರ್ಗ್ಯೂ ಮಾಡಿದಾಗ 11,000
ಅವ್ರು ಹೇಳೋದೊಂದು ಇಲ್ಲಿ
ನಿಯರ್ಲಿ 40 ನೋಟಿಫಿಕೇಶನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ.
He has come with some magnanimity. You also should recognize.
ಅಲ್ಲ, ನಾನೇನು ಹೇಳಿಲ್ಲ.
litigants ಪ್ರಕಾರ ಹೋಗಂಗಿದ್ರೆ ಆ ಜಡ್ಜ್ಗಳ ಸ್ಯಾಲರಿನ ಕೊಡ್ರಿ ಅಂತ ಕೇಳ್ತಾರ ಅವ್ರು. ಆ ಪ್ರಕಾರ ಹೋಗ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಅವ್ರ ಆರ್ಡರ್ನೇ ಪ್ರೊವಿಡೆಂಟ್ ಫಂಡ್ ಮಾಡಿ ಕ್ಯಾಶುವಲ್ ಲೇಬರ್ ಅಂತ ಹೇಳಿದ್ದು. ಪಿಟಿಷನ್ ನೇಮ್ ಇದೆ.
ಅವನನ್ನ ಫುಲ್ ಟೈಮರ್ ಆಗಿ ಟ್ರೀಟ್ ಮಾಡ್ಬೇಕು ನಾವು. ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಹಾಕೋರು ನಾವ್ ಇದ್ರಲ್ಲಿ. ಈಸ್ ಎ ಫುಲ್ ಟೈಮರ್. ಡೈಲಿ ವೇಜರ್ ಎಲ್ಲ ನಾವು ಒಪ್ಪಲ್ಲ. ಅವನನ್ನು ಫುಲ್ ಟೈಮರ್ ಪ್ಯೂನ್ ಅಂತಾನೆ ಟ್ರೀಟ್ ಮಾಡ್ಬೇಕು. ಫುಲ್ ಸರ್ವಿಸ್ ಅನ್ನು ಕೌಂಟ್ ಮಾಡ್ಬೇಕು.
3 years.
ಹೌದು,
ಬ್ಯಾಕ್ ವೇಜಸ್
ಈಗಲ್ಲ, ಸರ್ವಿಸ್ ಫುಲ್ ಕೌಂಟ್ ಮಾಡ್ಬೇಕು. ನಾಳೆ ಅವನಿಗೆ ಪೆನ್ಷನ್ ಇನ್ಶೂರೆನ್ಸ್ ಹೆಂಗಾಗಿದ್ರೆ
ಅಲ್ಲ, ಅದು ರೆಗ್ಯುಲರೈಸೇಷನ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಇವಾಗ. ರೆಗ್ಯುಲರೈಸೇಷನ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಇವಾಗ.
ರೆಗ್ಯುಲರೇಷನ್ ಬಿಡಿ. 4693 ಇಂದ ಅವ್ನು ವರ್ಕ್ ಮಾಡಿದ್ ನಿಜ ಇದೆ. ನಿಮ್ ಪ್ರಕಾರನೇ 17/4/2013 ವರ್ಕ್ ಮಾಡ್ಯಾನ. 20 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ.
ಅದು ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲಿ ಇದೆ. 74 ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ.
ಸೆಟಲ್ಮೆಂಟ್ ಇದೆ. 70 ಇಲ್ಲ, ಏನಿಲ್ಲ ಬರ್ಕೊಳಮಲ್ಲಿ. ಅದು ಬರಲ್ಲ. ಬಡವರವರು ಇಲ್ಲಪ್ಪ, ನಿಂತ ಕೋರ್ಟ್ ನಲ್ಲಿ ನಂಬಿಕೆನ ಹೋಗ್ಬಿಡ್ತದೆ. ಬೇರೆ ಶ್ರೀಮಂತರಿಗಾಗಿ ಹೋಗಿ ಕೋರ್ಟ್ ಬರ್ಕೊಳ್ಳಿ. ಕೂಡ್ರಿ ಕೂತ್ಕೊಳ್ರಿ ಚಟ್ರೆ. ಕೊಡ್ರಿ ಇಬ್ರು ಚೆನ್ನಾಗಿ
ಅಲ್ಲ, ನೀವು ಪರ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಇದೆ. ಬೇರೆಯವ್ರನ್ನೆಲ್ಲ ರೆಗ್ಯುಲೈಸ್ ಮಾಡಿದ್ ಬೇಕು. ತಾವ್ ಹೇಳಿದ್ರೆ ಮತ್ತೆ ಒಂದು ಕೇಳಿದ್ರೆ
ಸರಿ ಹೇಳಿ.
ಆಯ್ತು.
Petitioner, a workman, is grieving before the writ court against dismissal of his ID number 6 of 2014, wide order dated 18/4/2020, handed by CGIT another. CGIT Bangalore.
First Central Government Industrial Tribunal.
Central Government Industrial Tribunal.
61 ನಲ್ಲಿ ಇದೆ.
ಕುತ್ಕೊಂಡೆ ಹೇಳಿ. First. Learned counsel for the petitioner vehemently argues that the impugned order is bereft of any elements of justice apart from running counter to the canons of labor jurisprudence, and therefore is liable to be voided. First, he tells us that the power of writ court is coextensive with the powers of the tribunal whose proceedings are called in question, and therefore whatever the said tribunal ought to have made, comma, this court has to do under Article 227 of the Constitution of India. First, he has drawn our attention to the averments in the claim statement in the subject ID in support of his contention, and also the pages of TCR. First, next paragraph. Learned senior panel counsel appearing for the bank vehemently opposes the petition, contending that petitioner was only a daily wager whose services were engaged as peon whenever needed. Semicolon. He worked from 4/6/1993 during the period between 4/6/1993 and 16/4/2013, but not on regular basis. Semicolon. He never worked as a messenger at all. First off. However, the management, having stood tall, entered into a settlement dated so and so. Annexure R1, page 13 of your SO.
21/11/2016.
21/11.
2016.
2016, whereunder he has been reinstated in service with no benefit of back wages. First, the settlement binds the workmen who are parties to the union, members of the union, and therefore the order of the labor court, industrial CGIT, cannot be faltered. First, he vehemently opposes the claim of petitioner for back wages and for continuity of service. First, so contending, he seeks dismissal of the writ petition. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers along with the TCR, comma, we are inclined to grant a limited indulgence as under and for the following reasons. First, the petitioner was engaged as the workman during the period between 4/6/1993 and 16/4/2013 is demonstrated by a wealth of evidentiary material on record, and that he was prevented from continuing in service with effect from 17/4/2013, comma, whatever be the reason for that. First, a person who has put in about 2 decades of continuous service cannot be fired that way in a way without violating the canons of labor jurisprudence, which provides security of tenure to the working classes, which recognizes security of tenure to the working classes, along with emoluments. First, petitioner's ID 6 of 2014. ID. ಕುತ್ಕೊಂಡೆ ಹೇಳಿ primary school 2014 had raised the grievance as to termination from service and had sought for reinstatement along with all consequential benefits, including continuity of service and back wages. First off, that was stoutly resisted by the management by banking upon the settlement in question. First off, the CGIT was swayed away by the submission of the management and denied relief to the petitioner. First off, this it could not have done because the part of the settlement provided for the petitioner prosecuting ID 6 of 2014 on merits, notwithstanding his reinstatement. First off, this aspect of the matter has not been addressed by the CGIT, and therefore there is error apparent on the face of its order, warranting interference of this court. Next paragraph. It has been long settled position of law that where a wrongfully terminated workman is reinstated by the order of the court, stroke tribunal, or by settlement, ordinarily the back wages in whatever quantum should follow, coupled with continuity of service. First, denying back service will be very prejudicial to the interest of the workman, since terminal benefits depend upon the length of previous service. First, therefore, by a stroke of pen, the previous service on record, previous service cannot be erased from record, as rightly submitted by learned counsel appearing for the workman. First. Next paragraph. Learned senior panel counsel appearing for the respondent bank is right in telling us that in matters like these, award of back wages cannot be followed as a thumb rule. First, a host of factors enter the fray, including the gainful employment of the workman, and his potential employment during the termination period. First, some evidence has to be led by both the sides in this regard. Although earlier the burden to prove gainful employment was solely on the shoulders of the management. First off, be that as it may, first, justice of the case warrants that a portion of the back wages need to be paid, and regard being had to all facts and circumstances of the case, we fix it at the rate of 60%, at 60%, 60% of the wages then payable to the petitioner, plus 12% interest thereon.
6%.
No. 12%.
ಅಲ್ಲ ತಾವು minimum wage
There
see,
ಸುಮ್ನಿರಿ.
ತಾವೇ ಕೊಟ್ಟಿದ್ದೀರಾ 6%. 6%.
This we gain support from the decision of this court in Chandrasekhara Kambara versus
Very well.
Bangalore University, ILR, so and so. Next paragraph. The vehement submission of learned counsel for the petitioner that the respondent bank has granted regularization of service to hundreds of workmen who are on par with the petitioner herein, and therefore the same relief should be granted by this court, is difficult to countenance. First, learned senior panel counsel appearing for the management is right in pointing out that in that connection, a legal battle is being fought on the floor of the CJIT in ID number another.
ID number 22. ID number CR 22/2013.
ID number CR 22/2013. 13 between the union and the management. And therefore, we cannot derail the ongoing battle, since others also being engaged therein. First, next part. After all, we notice from the pleadings of the workman that there is no prayer before the CJIT seeking a direction for regularization. First, this is an added reason for denying the said relief. First, in the above circumstances, this petition succeeds in part. A writ of certiorari issue squashing the impugned order of the CJIT. In its stead, we direct the management to treat the petitioner as a regular workman functioning as a peon.
Casual.
Effect from case 4/6/1993, and count the entire back service for the purpose of career progression. However, the petitioner shall be paid the back wages at the rate of 60% on the wage structure as was applicable to him during the said period. That is, between 17/4/2013 and 23/11/2016. 24 join ಮಾಡ್ಯಾರ. with interest at the rate of 12%.
10% ಅಂತ ಹೇಳಿದ್ರು.
12%. First, if delay is within a period of, first of, this payment to be made within a period of 6 weeks.
From the date of receipt of the order.
Today it will be, it will be ready today. 6%. 6 weeks. First of, delay if brooked, the rate of interest becomes 18% instead of 12. All contentions of the parties relating to the ongoing ID are kept up.
Including regularization.
Including regularization.
Only one observation, may I request?
ಏನು?
Treat as regular work.
20 ವರ್ಷಕ್ಕೆ ವರ್ಕ್ ಮಾಡಿದವ್ರನ್ನ ನೀವು ಹಂಗ್ ಮಾಡಿಬಿಟ್ರೆ ಅನ್ಯಾಯ ಆಗಿ ಹೋಗ್ತದೆ. ನಾಳೆ
ಉಮಾದೇವಿ
ಕೋರ್ಟ್ ನಂಬೋದೇ ಇಲ್ಲ. ಹಂಗೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ.
ಉಮಾದೇವಿ ಕೇಸ್ ನಲ್ಲಿ
ಉಮಾದೇವಿ ಸರ್ವಿಸ್ ಅಪ್ಲೈ ಆಗಲ್ಲ, ಸುಮ್ನಿರಿ. ಇಂಡಸ್ಟ್ರಿ ಸರ್ವಿಸ್ ಅದು ಸರ್ವಿಸ್ ಸಂಬಂಧಪಟ್ಟ, ಇಂಡಸ್ಟ್ರಿ ಸಂಬಂಧಪಡಲ್ಲ.
ಆಯ್ತು.
Much obliged.
ಒಳ್ಳೆ ಸರ್ವಿಸ್. ಐ ಅಪ್ರಿಶಿಯೇಟ್ ಯುವರ್ ಫೇರ್ ಸ್ಟ್ಯಾಂಡ್ ಇರಬೇಕು. ಇವು ಶಟ್ರು ಬಿಡೋದಿಲ್ಲ ಇವರು.
ಅವ್ರ ಎಂಪ್ಲಾಯಿ ಅವರದ್ದು ಅವ್ರ ಮೇಲೆ ಕನ್ಸಿಡರೇಷನ್ ಮೇಲೆ ಸ್ವಲ್ಪ
ಏನು ಜಸ್ಟಿಸ್. ನಮ್ ಡ್ಯೂಟಿ ಏನು? ಟು ಡೂ ಜಸ್ಟಿಸ್. ಹೌದಾ? ನಮ್ಮ ಇದರಲ್ಲಿ ಏನೋ ನಮ್ಮ ತಿಳಿಸಂತ ಒಂದು ಜಸ್ಟಿಸ್.
Labor matters, I believe in settlement as far as possible.
Correct.
Because it would attain the finality.
Correct. Instead of fighting, go on fighting ಮಾಡ್ಕೊಂಡು ಬದ್ಲಿ.
If we invite the orders.
Correct. ಅದು endless. ಆಮೇಲೆ ಏನಾಗ್ತದೆ, ನಮ್ಮ ನ್ಯಾಯಾಲಯದ ಮೇಲೆ ನಂಬಿಕೆ ಬರಬೇಕು ಅಂದ್ರೆ ನಾವು ಬಡವರು, ತುಳಿತಕ್ಕೆ ಒಳಪಟ್ಟವರು, ಕೆಳಗಿನ ಸ್ತರದ ವ್ಯಕ್ತಿಗಳು ಅವ್ರ ಕಡೆ ಗಮನ ಕೊಡಬೇಕು. ಶ್ರೀಮಂತರು, ಶಕ್ತಿವಂತರು ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಕೆಲಸ ಮಾಡ್ಕೋತಾರೆ, ಅವ್ರಿಗೆ 10 ದಾರಿ ಇರ್ತಾವ. ಇವ್ರಿಗೆ ಹಂಗಾಗಲ್ಲ, ಕೋರ್ಟ್ ಒಂದೇ ದಾರಿ. ಹಂಗಾಗಿ ನಾವು ಹಂಗೆ ನೋಡ್ಕೊಂಡು ನಾಟ್ ಮೇಂಟೈನೇಬಲ್, ದಿನ ಇದು ಕರೆಕ್ಟ್ ಇದೆ ಹಂಗೆಲ್ಲ ಹೇಳ್ಬಿಟ್ರೆ ಜಸ್ಟಿಸ್ ಮಾಡೋದ್ ಹೆಂಗೆ? ಬಹಳ ಜನ ಶಾಪ ಹಾಕ್ಬಿಡ್ತಾರೆ.
ಕೇಸ್ ಮುಗಿತಲ್ಲ, ಅದೇ ನಮ್
ಹಂಗಾಗಿ ನಾವು ಟೈಮ್ ಕೊಡೋದೇ ಇಲ್ಲ.
ಅಲ್ಲ, ಮುಗಿಸಿ ಕೊಟ್ಟರು
6 days. ಓಕೆ
ಮುಗಿಸಿ ಕೊಟ್ಟರು. ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೇವೆ. ಇವತ್ತು ಒಂದು ಪೇಪರ್ ಇದೆ. ಒಂದೇ ಒಂದು ಕೊಟ್ಟರು ಇಲ್ವಾ?
ಸರ್ ಅದು ನಾನು ಬರ್ಕೊಂಡ್ಬಿಡ್ತೀನಿ. ಸಿಕ್ತಾ? ನಾನು ಹುಡುಕಿ ಸಾಕಾಯ್ತು ಗೂಗಲ್ ಅಲ್ಲಿ. ಅದೇ ನೀವು ಆಪ್ ಇದಿಟ್ಕೊಂಡಿದ್ದೀರಾ ಈಕ್ವಲೆಂಟ್ಗೆ? ಇಂಡಿಯನ್ ಕ್ಯಾಮೆರಲ್ಲಿ ಹಾಕಿದ ತಕ್ಷಣ ಬಂದ್ಬಿಡುತ್ತೆ, ಬಟ್ ಇದ್ರದ್ದು ಬರ್ಲಿಲ್ಲ ಇವತ್ತು. ಇದು ಬರ್ಲಿಲ್ಲ, ಬೇರೆದ್ ಬರುತ್ತೆ.